Friends, I just pressed the let's go live button, which means we gotta wait for the stream to fire up all across the fruited plain of the internet before we go ahead and get started. We gotta make sure the tubes are working. Of course, it is a beautiful Tuesday, and we can't start the show until we can make sure the internet works. And it looks like it is working, which is tremendous. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia, and today we're talking about Donald Trump suing the media for $1.5 billion. And we always like taking a look at a good Trump lawsuit, especially when it's going after the media. And this one involves the Truth Social company. And it's not a super long lawsuit, so we'll take a look at it. It's going out of Florida, and it's versus a bunch of other people. Guardian, Salon, Newsweek, tons of people. And we're going to look who's in that list, including Rolling Stone and others, because he wants $1.5 billion, $1.5 billion, which I think is about what Mar-a-Lago is worth. So he really wants one Mar-a-Lago in exchange for some of their dishonesty, saying that they committed defamation. And so we're going to have a quick segment on that. Then we're going to have another pretty quick segment on Elon suing Media Matters for concocting a scheme to try to get rid of advertisers on our beloved X platform. And so we're going to take a look at this lawsuit because Elon is suing. This one has been filed in Texas, in Fort Worth. It's a 15-pager, not too long, so we'll take a look at that one. And then Ken Paxton, the Texas Attorney General, is joining in on the fun. He says, you know what? If Media Matters is going to try to create an environment that is dishonest, that is kind of like, fraud. And so they're going to investigate it, and we'll see what Ken Paxton has to say about it. Couple quick reactions from Elon Musk and from Linda Yaccarino, who is the new CEO over at the X organization. And so we'll go through that one. And then the big news of the day, my friends, which actually still might be going on as we speak. In fact, let's just take a look. What's happening here? Is it over yet? No, they're still waiting for the judge. So what we're watching, what we're going to be tuning in on is this hearing. And so this has been going on all afternoon. You can see Floyd is right here. Harrison Floyd is seated right there. And he is not going back into custody today. Whew! And so we're going to go through this. If you missed it, kind of a long hearing, I think of over 2 hours or so, 3 hours at this point. Yeah, over almost 3.5 hours. So we're going to hit the highlights of it. I want to hit the opening statement from Fani, because she came out. She was there. Fani was in court today. We're going to go through opening statement. We're going to hear, there were a couple witnesses. We'll just listen on that one. And then we'll hear some closing arguments from the defense. And then we're going to wait for the judge's ruling. Now, Harrison Floyd is not going back into custody, but these are nail biters, right? So there's a little tension coming in the judge's opinion. But of course, we already told you what the outcome is. Sorry, spoiler alert. But we're going to go through all of that and more today. You can see Fani was there in the courtroom looking around. What's going on? And she's not happy. As soon as the judge came out and said Harrison is not going into custody, well, then she threw a little bit of a temper tantrum, a little bit of a fit out there, and made a bunch of noise. And so we'll listen to see what she had to say about it. But as you can see, we've got a lot to get to today. We got some Elon stuff. We got some Trump lawsuit stuff. This morning, we had a great members only stream. And so we'd love it if you became a member, whether you're a YouTube member or a member over on watchingthewatchers.locals.com. This morning, we had a fun conversation about Trump roasting Joe Biden with his health report, right? Yesterday was Joe Biden's birthday, and he posted that cake of presidential death, which was symbolic of what he's doing to the country. It was like 81 candles with flames flying all over the place, and he's holding onto the table for dear life. Well, we talked about that because Trump, simultaneously to that picture being released that they posted on Instagram, we also saw that Trump has a clean bill of health. Excellent. He's doing great. So that's good news. We also had a story about the left panicking. There was a big Eighth Circuit ruling that came out. So members, we covered that today. It was very interesting. The Eighth Circuit was saying that there's no private right of action for people like Mark Elias and Democracy Docket to come and file lawsuits against secretaries of state and things like what we saw in Colorado with the ballot removal efforts and so on. And so the 8th Circuit came out and said, can't do that anymore. And Mark Elias and Democracy Docket called it catastrophic. Okay, so we covered that this morning on our Membos stream. That segment will be out later for everyone else, my friends. But if you want to become a member, the best place to do that is by joining us at watchingthewatchers.locals.com. And we have a lot of fun over there. We stick around for the members only after party after the show is over. So if you're a member, stick around. If you're a YouTube member, you can join us, but you have to join us by grabbing the Telegram link. It's a private link just for members. So grab that in the community tab section on YouTube, and we'll see you over there. We've also got all the PDFs that we're about to go through, all the documents, all the videos that are clipped out are going to be published at robertgovea.com. And so if you want to read the red lines, if you want to see some of the documents we covered today, if you want to access the mind map, if you want to sign up for our daily newsletter so that all the news gets delivered to your inbox without you having to do a thing, robertgovea.com is the place to go. And we'll look forward to seeing you over there as well. All right. Now, without any further ado, let's get into the day's business, because we've got some business to attend to. Starting now, Trump sues the media, and he's asking for a whopping $1.5 billion. And I hope he gets it too, because they lied about him. They said that $73 million of lost revenue was something that hit one of Trump's companies, this one ahead of the True Social Network, Trump Media and Technology Group. They're suing a bunch of these people, and we're going to look at what is inside. You can see this is the complaint. This one is filed out of the 12th Judicial Circuit out of Sarasota County, Florida. This is a state-level case, so it's a civil division. And you see here it's Trump Media and Technology Group suing. Look at all these people. You have here Guardian News, Hollywood Reporter, McClatchy, Reuters, Miami Herald, Alex Mena, News and Media, Nexstar, The Hill, Deadline Hollywood, MarketWatch.com, Benzinga got nailed, Forbes Media, Axios popped, Daily Beast got them, Salon.com, New York Daily News, Newsweek, MSNBC, oh, Rachel Maddow and Jen Psaki are so upset, and Mediaite and DMG Media, Daily Mail, CNBC, and everybody basically got served on this one. And so here is what Trump says. It's a complaint, civil complaint. He's demanding a jury trial on this, and he's asking for some serious damages. And if you want to just see what that looks like, let's just hit it right there. Oh, boom! Look at that number, man. And I had to count the commas and the notations here. $1.5 billion is what the final number is. Let's see what the damages entail and what Trump's team alleges. They say, all right, Judge, this case is about an unprecedented and seemingly coordinated media campaign by no less than 20 major media outlets, some might say colluding or collusion, to attack Trump Media and Technology Group and its social media platform called Truth Social by falsely reporting that TMTG had lost $73 million. Now, they say this number was an utter fabrication. Each defendant, in apparent coordination, okay, every one of these media companies, in apparent coordination, reported the exact same false number within approximately 24 hours of one another. And what did they cite? A Public Securities and Exchange Commission filing in which the mystery $73 million loss appears nowhere. Well, that's weird. They're citing a document that doesn't exist. Do they think that they're ChatGPT or something? Are they hallucinating? That's curious. Now, let's just defend the media for a second, okay? They are idiots, and they don't do anything creative, okay? They're basically copy and paste machines. That's all they do. Copy and paste journalism. I mean, at least we show the documents here before we read them, okay? They just take a paragraph and copy and paste it out of the document and put it in their article, and they call that content. And they say, oh, and then they don't actually give you the document. And then they don't offer any real analysis other than saying that if you disagree with them, you're a racist bigot and Trump is wrecking America. Whatever the story is, that's always where it goes. So in fairness to them, they do just copy and paste everything, okay? Because they're not original. So somebody just made this up, like one person, one idiot in this list. We don't know who it is. And then they publish it and they're like, I'll put it on my Substack. And they put it out there and then they retweet it. And then all of the smooth brains, every one of them are just so smooth brain. Nobody fact checks anything. They just copy and paste it and they put it in their article. And this is how it works. This is how it works all the time. And all you need is one fake story and then it just catches fire. Or let's say a non-fake story and they all take it. Like they're not fact checking anything. They're going to sit here and tell us that they're all vetting information, but they're not. Trump says it appears literally nowhere. Now, they say this was a coordinated effort to damage Truth and Trump's reputation, to degrade the firm's financial standing, to freeze its access to capital, and to torpedo the anticipated merger between Digital World Acquisition Corp and TMTG. They say on November 13th, DWAC submitted an amended S-4 registration statement with the SEC. That marked a major milestone toward the completion of a planned merger between the two companies. Truth publicly stated that the S-4 was good news for the company. Now, because this filing involves TMTG and President Trump's Truth Social, however, these defendants, the media, they ignored or they downplayed TMTG's public statements about a positive development. They didn't want to talk about that good news. Instead, they deliberately and recklessly published false financial information to advance a preferred and a coordinated narrative harmful to TMTG. Saying all defendants ran nearly identical headlines, because again, maybe it's collusion, probably, but they could also just be, not uncreative people, which I think is true, that reported some variation of Trump's Truth Social lost $73 million. And they have a whole spreadsheet showing us what this looks like, but we'll get there. They say on November 14, 2023, not too long ago, TMTG contacted each of these media defendants and we notified them in their writing of their error. We specified that their statements about a $73 million loss were false and defamatory. Bunch of lawyers like, what did you say, punks? And we demanded a retraction and an apology, trying to settle this like adults. But to date, while some defendants have issued little notice, quote, corrections or whatever updates, none have retracted the defamatory articles, publicly apologized, yeah, good luck, or taken any other steps to ameliorate the continuing damage. Now, although TMTG, says Trump's team, although they'll continue pursuing its mission and our planned merger with DWAC, the widespread misreporting across the entire media landscape has nonetheless deeply harmed TMTG, eroding faith in the company's operations and management, and making it more difficult for TMTG to raise capital, additional capital, to fund operations while its planned merger with DWAC is pending SEC review. Saying existing investors and potential investors alike were concerned by the false stories. Now they continue saying TMTG intends to hold these reckless and malicious media outlets, the ones we just named, to account for their false reporting and for their seemingly coordinated effort to destroy TMTG and Truth Social. Carrying on, they tell us who these people are. Of course, the plaintiff, TMTG, incorporated in Delaware and headquartered in Florida. Guardian News, we know, Hollywood, all the media companies, Market Watch, blah, blah, blah. We already listed all these people. We know we're filed here in Georgia. I'm sorry, that's Fani's case. This is in Florida. They say here, TMTG is a startup technology company. We're going to get into some factual backgrounds here that justify that $1.5 billion damages. They say they were created and operate a company and a platform called Truth Social. Writing, though relying on bridge financing to compete against dominant tech giants worth tens of billions of dollars who spent all of 2020 censoring him and then throwing him off of them. In America, by the way, can you believe that? Can you remember when they did that? Trump, you're banned. But I'm the president. Oh, sorry, you're banned. No, but I'm the president, and there's like tens of millions of Americans who want to hear from him. We don't care. We're more powerful than you. We have the FBI and the DOJ on our side. Get off our platforms. So they did that. So then he created his own. Now he has to fund it with some bridge financing. They say Truth Social developed its own infrastructure and now gives millions of Americans the opportunity to freely express their views, culture, politics, art, sports, entertainment, any other topic that you want to talk about on Truth. Now, in addition, in October 2021, TMTG and DWAC, a special purpose acquisition company, announced their intention to effect a merger, which would result in TMTG becoming a publicly traded company, thereby enabling retail investors who support the mission to invest directly in the company, talking about us. Now, completing the merger is a crucial part of the business plan, as repeatedly expressed in public statements by both companies and in DWAC's public filings. But on November 13th, DWAC submitted an amended registration. They say this is a major milestone. We're going to merge. All this is publicly available. But the same day that they submitted this, a major milestone, the media came out as they do. Continuing into the next, the same day, multiple days, numerous media outlets, including the defendants named here in this suit, in apparent coordination with one another, ran materially identical headlines and stories. And they each cited to the S4 filing, the same one that is here. They cited to the filing with the SEC, and they falsely claimed that the S4 showed that the TMTG lost $73 million. Oops. The $73 million figure appears nowhere in the S4 or anywhere else. It was a complete fabrication, a fabrication made by these 20 defendants within a 24-hour period. Doesn't even exist in the document. That's the media. Because they just copy and paste and they lie. Both of them. I'm like, well, reading S4 forms are hard. And journalists have a tough time reading anything that doesn't support their narrative. So they just copy and paste it. Like that's all they do. And as you can see. Now, the following defamatory headlines and statements were published by the defendants. It says here, Hollywood Reporter headline, Trump's Truth Social has lost $73 million since the launch. Right here. It says Trump lost $73 million. The filing revealed that Truth Social lost $50 million in 2022. Miami Herald, we got another exhibit. They say the same thing. Trump lost 73 in 2 years. The form that apparently they looked at shows that Truth Social lost 50 million on just 1.4 million of net sales. This one, Miami. Reuters said the following. Former President Trump has lost 73 million since its launch. Copy and pasted that line too about the 50 million in 2022. The Hill, it's just copy and right. They're idiots, as I said, right, and liars. So you can just imagine. He's just sitting there, copy and pasting documents. He's like, I'm doing a great job saving America, stopping Trump. Did you even read it? No. So Benzinga, Market Watch, same thing. Truth Social lost 50 million in 2022. They are copy and pasters. They don't do anything meaningful. So Gizmodo also posted it. The company lost 50 million in 2022. The embarrassing financial news was laid bare in a filing made public this week. The shell company behind the flailing attempt to take the social media company has lost a massive $73 million. MSNBC, I wonder who said this. Was this Maddow? Or was this inside Jen Psaki? I don't know. But Daily Mail, CNBC said the same thing, right? They're all same statements over and over and over again. All just fake. So they say the statements above, also found in corresponding exhibits, are collectively called the defamatory statements. They say here, the Miami Herald article referenced in earlier paragraphs, 44B, and attached as Exhibit B, purports to be a republication of the report from The Hill from November, and Miami referenced this other article, which was a republication on this. Now then, defendant Alex Mina, so maybe we're getting to the source of where all this originated, the executive editor of the Miami Herald made the editorial decision to republish the recklessly false reporting of The Hill in the New York Daily News. So it started with Miami. Additionally, the Miami Herald's version of the New York Daily News article was, quote, updated. maintaining, so maybe it started with the New York Daily News. It's hard to tell where this came from. But we continue. Maintaining the false $73 million loss. But the New York Daily News revised its article to remove that false number. They said, no, sorry about that. But defendants Miami Herald and Alex Mina are responsible for their editorial choices, and they continued to publish what they knew to be false and defamatory information. Now, they tell us the $73 million loss figure does not appear anywhere in the DWAC S4 filing. And the defendants knew that it did not, or they were at least reckless in their disregard for the truth, because each of them had access to the publicly available S4 form that was the purported basis of their articles. Now, indeed, many defendants cited to or directly quoted from the filing. They tell us that another false statement made by 19 of the 20 defendants, all except for Axios, was to claim that the SEC filing showed a loss of $50 million in 2022. Yeah, but no loss is shown on the DWAC S4. I'm not saying that. Now, so they say each of these defamatory articles has been viewed millions of times, including by residents of Florida. And as a result of these widespread lies, TMTG has suffered actual damages. Committed and potential investors have reacted negatively to the false news of TMTG supposedly losing $73 million, and TMTG's ability to raise additional capital has been impaired. Yeah, it's a big number. Why would you want to invest in a company that's losing tens of millions of dollars every year? Now, defendants are ostensibly, they say, in the business of publishing, this is the media, the so-called, they're in the business of publishing factual information. Yeah, you're right. That's funny. But nice job, Trump team. However, their business models revolve around generating clicks, right? And driving views to their websites, no matter what is even on there. And anti-Trump stories sell, baby. In this case, the media used the occurrence of a news event, which in this case was the filing of DWAC's S4 with the SEC, which was a significant milestone, by the way, for this proposed merger. But they used it as a pretext to intentionally or recklessly report the fabricated $73 million loss figure and sensationalize the news with anti-Trump clickbait articles. They continue saying the incredible circumstances of all the 20 defendant media companies publishing nearly identical articles within hours of one another, using the same fabricated figures that appear nowhere in the S4 filing upon which they ostensibly rely, yeah, right, would seem nearly miraculous without a coincidence. Well, this is a real, the guy who writing this is a very, good-natured person. Shout out to Jared Roberts out there. He's presuming, because he's a nice guy, that the media writes their articles. See, that's like that. You have to, that's the premise upon which all this is based in order for it to work. Like, it does seem crazy. Okay, if we're all out here, watching the same thing, we all write the exact same headline together, right? You and me, everybody watching the show, we all write the same thing together. That would be strange. Like, how is that possible? But if one of us wrote it and then everybody just copied it, you could do that very quickly, right? I mean, we could do that. I could just post something and then you could copy and paste it and we could all just do the same thing. But since we're honest people and we work for, our employers and the people who we work with, we would write our own thing, right? We're not like these people in the media who just steal other people's work and copy and paste a bunch of stuff and don't come up with anything creative. And then don't even link you to the document and the PDF in their articles. Drives me nuts. You go to the New York Times, they'll say a judge ruled and then copy, paste, copy, paste, copy, paste. And they leave out the stuff they don't want you to see. And then they don't even link you to the article, which they have, the PDF, of course, somewhere. But they want to filter the information to you. But anyways, these people, the reverse of this is happening, okay? They want it to be the same. The opposite is true. If one person can make a lie and then they all support each other with the lie, a lie told long enough, right, often enough, becomes the truth. So instead, this chorus of falsehood, they say, it evinces a deliberate, malicious, and coordinated attack on TMTG and Truth Social. So claiming, upon information and belief, There are likely to be other parties involved in this coordinated campaign that would stand to benefit from the damages caused to us. If they're going to be colluding against one person, probably going to be colluding against others. So they have different causes of action here, one being defamation, saying Trump incorporates everything we just discussed, and they write, on November 13th and 14th, the media companies, they engaged in a concerted effort to destroy TMTG. The media have spread lies and spread the lie that a public SEC filing by DWAC showed TMTG has lost $73 million since its launch. However, the media's defamatory statements are false. And the defendants published these articles to residents of Florida, the jurisdiction in which we reside and are filing our claim. And they've directed the articles at a Florida social media company that's based in Sarasota. Now, defendants, the media, they use their lies to drive viewers to their company, and they did it to increase their own revenue streams to get those juicy clicks, baby. Don't forget to hit that like button. Now, the media published the defamatory statements knowing that they were false or with reckless disregard for the truth. They did it intentionally. They copy and pasted it to spread the damages. Now, information regarding the true number was publicly available in the DWAC S4 filing. It's all there. You can see it with the SEC. The defendants purported to rely upon it, and in many cases cited to and quoted from the SEC filing, but it didn't exist. But they instead went forward with this lie. They published it, and because of their political animus and the opportunity to increase their own revenue streams, they did it. Now, they say the defamatory statements, they constitute defamation per se. It's just defamation. Why? Because the defamatory meaning is obvious on its face, okay? Claiming a company posted a $73 million loss when it did not is obviously defamatory because it creates a false negative impression about the financial condition of the company. And they say the defamatory statements have directly and proximately caused TMTG to suffer actual damages in Florida, where it does business. These damages were foreseeable to these media companies. They're in the business of not defaming people and facing lawsuits. Now, defendants publish these defamatory statements. They did it knowingly. They did it intentionally. They did it willfully, wantonly, and maliciously with the intent to harm Trump or in blatant disregard for the substantial likelihood that these statements would in fact cause harm, specifically in the state of Florida, and Trump is entitled to an award of punitive damages. Ugh. Now, as direct and proximate result of the misconduct, they say TMTG is entitled to compensatory, special, and punitive damages, as well as disgorgement of any and all income that the media have made off their lies about TMTG. Plaintiff has another claim, injurious falsehoods against all the media companies, saying that, of course, True Social is a media company, and the merger is crucial to the continued raising of capital to enable it to compete against the other big tech companies. And they say that the false accusations that the company lost $73 million is damaging. Now, they intended, when they made those statements and published those false stories, they intended their false assertions to gravely harm the company by degrading their reputation, their financial standing, their access to capital, and prospects for completing the actual merger they needed to do. They say the media reasonably recognized, and they even intended, that the publication of its assertions would result in pecuniary loss. They did it to shake the market. TMTG has suffered as a result direct pecuniary losses as a result of these media accusations, which includes costs associated with lost business opportunities and resources to defend itself against the media's false statements. Trump has to hire lawyers to go and address this. Now, they continue. This is what they're asking for. Your Honor, Trump Media and Technology Group respectfully requests this court enter a judgment in Trump's favor and grant relief against the media companies in the following manner. 1, grant an award of compensatory, special, and punitive damages, as well as disgorgement, take that money out, of any and all income that the media companies have made off their lies about TMTG in the amount of $1.5 billion. And that's a lot of super chats. Now, injunctive relief, they say, we also, Your Honor, we want you to stop them from publishing and republishing these defamatory statements and make them stop. We also want attorney's fees and any other relief that this court deems to be just and appropriate. Signed by Jared Roberts, submitted on behalf of the Trump Media and Technology Group in Florida. And of course, we'll be looking forward to seeing what the media says about this. You know, the only thing that we were missing with the collusion here with all these media stories was basically the CIA, the CIA and Anthony Blinken and the rest of them layering in on this and saying, no, it's true. It's true. There's no evidence that Trump didn't lose $73 million, and there are all the hallmarks of a loss in the $73 million, okay, something like that. So the media is fake, okay? They're liars, they're copy pasters, they don't do anything, really useful a lot of the time. They copy from the actual documents for their own articles, and then when they don't know how to write or read, when they find something that is useful against a political opponent, when they can maybe shake the markets to stop a merger or to scare off a bunch of investors, they do it. They copy and paste it. I don't know if they have a group text message or what they're using, but it's pretty clear what they're doing. They're dunking on one side of this to protect their side, and it's lawfare in action. Today, Trump is responding, filing a complaint against them. Of course, we'll continue to follow this case and others. We'll see what the media does in response to this. Thank you for subscribing. Thank you for joining our channel and coming on back here for our daily live streams, inviting somebody to join you when you do. And we'll look forward to seeing you back here on the next one. All right. Now, that is the Trump suit. And we've got 2 more segments to attend to. So we've got Elon coming up, and then we're going to jump into the Fani case. But let's just pause and see. Are they done? Are they still going over there? They're still going. All right. So they're still fleshing out the, sounds like the judge is not back yet. All right, so they're still fleshing out the final order, which is good. We're not going to have to wait through all this. We're going to do the second segment, and we'll see if we get some conclusions on the final order when it comes out. So let's get into a little bit of this segment, which of course is kind of related to the media, which is a story that we just talked about. So now we'll see what Elon says about the line media and media matters in particular. Let's get to it. Elon Musk is suing Media Matters, and Ken Paxton from Texas is joining in on the fun, launching an investigation into Media Matters. And the reason is because the allegations are that Media Matters concocted a scheme saying that the X platform, which of course Elon bought, is putting advertisements against racist comments, and that was something that should scare the advertisers away. And so we saw a big running of Apple and Disney and all these other weenies. We're scared. And they ran away. Turns out the story may not be true at all. And Ken Paxton says that Media Matters may have committed fraud. He's launching an investigation into this by diving into the allegations that they made. Now, Elon promised a lawsuit here in response to all of this stuff happening on the X platform, advertisers leaving and the smears becoming more prevalent. Elon filed this lawsuit in Fort Worth, Texas, the great state of Texas, and it's a 15-pager, and he is bringing it against Media Matters for America, and he's also naming Eric Hananoki. So you see X Corp from Nevada suing Media Matters for America. This is out of the Northern District of Texas, Federal District Court, Fort Worth Division, demanding a jury trial. Here's what Elon and X say. They write, "The defendant Media Matters for America is a self-proclaimed media watchdog that decided it would not let truth get in the way of a story it wanted to publish about X. You know, that pesky thing called truth? Media Matters, they want to stop X. And if X is not racist, that's not good for them. So they got to make it happen. So looking to portray X's social networking platform as being dominated by, quote, white nationalist and anti-Semitic conspiracy theories, Media Matters knowingly and maliciously manufactured side-by-side images depicting advertisers' posts on X beside neo-Nazi and white nationalist fringe content. So they put these images side by side. They said, see what X is doing? Every time Apple wants to advertise their new product, it shows up next to some racist, bigot, white nationalist, MAGA extremist. It's not true. And then they portrayed these manufactured images as if this is what typical X users experience. But the truth is, Media Matters designed both of these images and the resulting media strategies to drive advertisers from the platform in an attempt to destroy X. So Plaintiff X operates the X social media platform. They've got 500 million active monthly users. That's a big number. And X facilitates free expression and open discourse by enabling its users to create and share their own content and to message and comment on other users' posts. And of course, we're very grateful for X. We have faced a lot of censorship here. We've had multiple strikes here for medical misinfo, election misinfo. We had demonetization for 9 months after January 6th. And we're grateful that there is now competition in the form of X and of course Rumble and of course our locals. There's a lot of alternatives now. But the other side does not like that. So these posts appear sequentially to users in feeds, which is occasionally inclusive of paid advertisements, and that is the overwhelming source of X's revenue. Now, users shape their own experiences on X. Users curate the content on their own feeds. They get to choose who to follow, and thereby they determine which posts are presented to them. Most users are served a variety of content based on an algorithm that takes account of who that user follows and what that user engages with. But X also provides its users the option to forego algorithmically suggested posts altogether, and thereby enables a user to view only the content that the user chooses to view. As the most prominent online platform dedicated to hosting free speech, X and its predecessor, Twitter, have long been the target of Media Matters. In fact, in just the last year, Media Matters has published a series of articles threatening X's relationships with massive multinational advertisers and global publishers, people like Amazon, pretty big company, eBay, Major League Baseball, New York Times, Samsung, Sports Illustrated, Wall Street Journal, USA Today, Office Depot, Nokia, Dish, Bayer, Tyson Foods, Honeywell, Discovery, FanDuel, Thermo Fisher, National Women's Soccer League, and more. This November alone, Media Matters, this so-called watchdog, they released over 20 articles and counting, disparaging both X and Elon Musk. This is a blatant smear campaign. And here's just one footnote. They said X, this is an article from MediaMatters.org. X is placing ads on Amazon, NBA, and all these things, and it's next to white nationalist content. Now, for the last several years, this is from Eric, right? Eric Hananoki is posting this. Musk's team says, for the last several years, Media Matters has falsely portrayed Twitter, now X, as a risky, unsafe platform for advertisers. Now, contrary to these efforts, 99% of X's measured ad placement in 2023 has appeared adjacent to content scoring above the Global Alliance for Responsible Media's brand safety floor. But undeterred by the truth, love that line. They hate the truth, man. They just make it up as they go. Media Matters has opted for new tactics in its campaign to drive advertisers from X. Media Matters has manipulated the algorithms governing the user's experience on X to bypass these safeguards and to create images of X's largest advertisers' paid posts adjacent to racist, incendiary content leaving the false impressions that these pairings are anything but what they actually are. They're manufactured, they're inorganic, and they are extraordinarily rare. But Media Matters doesn't care about the truth. They hate it. Media Matters executed this plot in multiple steps. And how do we know this? X has the data. Their internal investigations revealed the following. First, Media Matters accessed accounts that had been active for at least 30 days, bypassing X's ad filter for new users. So, Media Matters then exclusively followed a small subset of users consisting entirely of accounts in one of two categories. So they created an account and they bypassed X's ad filter for new users. So I guess these were not new accounts. Okay, so they went and got like old accounts and they started running tests on old accounts, it sounds like. Accessed accounts that had been active, so they're not new. And then they exclusively followed a small subset of users consisting entirely of accounts in one of two categories. So they type in some racist words, they follow everybody. Like anybody who like looks like they're doing extreme fringe content, they follow. Those known to produce this content. And accounts owned by X's big name advertisers. So do you see what's happening now? So they're creating, they go and they follow like 1,000 of X's worst people to try to fill the feed, just pummel it full of bad content, right? And then they follow the advertising companies like Apple and Disney and all the others so that their posts also show up in between the two. Now, the end result was a feed precision designed by Media Matters for a single purpose: to produce side-by-side ad content and screenshot it so that they could send it to the advertisers. Look at what your ads are doing. Look at your content. Now they say, but this activity, okay, even though they tried to do that, which is about as dishonest as you could possibly get, they said, but this activity still was not enough to create the pairings of advertisements and the content that they wanted to produce, because they weren't the advertisements, right? So like, if you just think about your feed, let's say, you know, it's a racist bigot post right here, racist bigot post right here, racist bigot post right here, but then you get an Apple post, right? It's just an Apple post. We, you know, disambiguate that with the squiggly. And you say, okay, but that's not an ad, right? That's just a post. And it's a racist post here, racist post here, racist post here. But what you really need is an ad. Like you need the ad there. So Media Matters therefore resorted to endlessly scrolling and refreshing its unrepresentative, hand-selected feed, and then generated between 13 and 15 times more advertisements per hour than viewed by the average X viewer. Okay, so they're just on the feed, refresh, 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 refresh. I just need an ad to show up. Like, show up, just show up, please, please, please. Please. And then they repeated this inauthentic activity until it finally received pages containing the result it wanted. Finally, we got an ad. Controversial content next to X's largest advertisers and their paid posts. So then they refresh. Now it's racist, 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 racist. Disney ad. Racist, 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 and they did it. Took them like 30 times. Refresh, refresh. If you use Twitter, you refresh it. Your boy does that all day, refreshing, refreshing, refreshing. Now, Media Matters omitted mentioning any of this and didn't tell us about this methodology, which, I mean, obviously, like, that's not going to happen for most people, obviously. They're not going to go and follow a bunch of racist content and bigoted content on purpose and unfollow everybody else and then just refresh in order to get the ad so they can screenshot it for their fake articles. But Media Matters doesn't mention this. Instead, they just publish the article. It's everywhere. Every time you open up X, it's all there. No, not true. And they displayed instances of the things that Media Matters so-called found of X's advertisers and their paid posts that were featured next to neo-Nazi and white nationalist content. Nor did Media Matters otherwise provide any context about the forced, inauthentic nature and the extraordinary rarity of these pairings. No, of course not. It served their ends. However, Relying on the specious narrative propagated by Media Matters, these liars, the advertisers targeted took these pairings to be anything but rare. They said, oh my gosh, our ads are next to Nazi content? With all but one of the companies featured in the Media Matters piece withdrawing all ads from X, which is really, reprehensible from those companies, including Apple, Comcast, NBC Universal, IBM. Some of X's largest advertisers all bailed because they're like, oh no, we don't want to be seen. Now, indeed, in pulling advertising from X in response to this intentionally deceptive report, IBM called the pairings an entirely unacceptable situation. We can't believe this is happening. Only Oracle did not withdraw its ads. Shout out to Oracle for not being morons. Now, the truth, all these other people, right, can't figure it out. They just, oh, Media Matters. Oh, we're scared. The truth bore no resemblance to Media Matters and their narrative. In fact, IBM, Comcast, and Oracle, their paid posts, their ads, they appeared alongside the fringe content cited by Media Matters for only one viewer. They have the data. What post are you talking about? Let us look at the analytics on it. The post appeared only alongside one viewer out of more than 500 million on X. Pretty small. And guess who that user was? Guess who saw that ad? Media Matters. It was their account. Yeah, the account they created. Not a single authentic user on the X platform saw IBM, Comcast, or Oracle's ads next to that content. And Media Matters only achieved it through their manipulation of X's algorithm as described above. And in Apple's case, only 2 out of more than 500 million active users saw its ad appear alongside fringe content in the article. And of the 2 that saw Apple, only 1 of which was Media Matters. So their own people saw the alleged offensive content. Now they say Media Matters, they could have produced a fair and accurate account of the interactions with the advertisements. They could have just done some basic reporting, not complicated. 1, following actual real users, documenting the actual organic production of the content. Had it done this, however, it would not have produced the outcome that Media Matters desperately desired, which is to tarnish X and the reputation by associating it with racist content. So instead, Media Matters chose to maliciously misrepresent the X experience with the intention of harming X and its business. We know who the parties are, and we know that Eric Hanananoki is a writer for Media Matters, and he lives in Maryland. Now, we know that these companies are located in different locations, and here is what Elon says. X is a social media platform that remains in operation due to its loyal users and advertisers. They invest heavily in technologies that work in tandem to facilitate safe interactions. And as a first layer of protection for advertisers, X applies default protections to all posts. They're designed to prevent the advertisements from being placed next to content that violates the guidelines. When users operate within the community guidelines, these default mechanisms are effective. Now, as a second layer of protection, X provides advertisers with opt-in options that allows them to specify keywords that they do not want their post to appear by. These safety protocols have been protecting the brands for some time. Media Matters knows this. And they continue saying that these things work. That's why Media Matters had to systematically manipulate the user experience to get the results they wanted. On November 16th, Media Matters published a fake article saying X has been placing ads for these companies next to pro-Nazi content. They say that X was responsible for anti-Semitic content being paired with advertising posts, but this statement is not true. Media Matters knew it. As explained below and displayed in an X internal review, the title is false, in that Media Matters itself, not X, was responsible for the placement of the content it identified. And it specifically intended to bring about that content. They, in fact, tried to get around the safeguards that prevent the platform from showing these things. But in the body of the piece, Media Matters falsely claimed that it recently found, right? It found these things. No, it didn't. You created them. They didn't find pairings. Media Matters created these pairings in secrecy to manufacture the harmful perception that X is incompetent or somehow indifferent, or even at worst, encouraging Nazi and racist ideologies. Now on X, users can control the content in their feeds, but Media Matters exploited these provisions. X's internal user data tells the story of just how far Media Matters went to manufacture this inorganic user experience. First, they set out to attempt to evade X's content filters for new users. They specifically got accounts that have been in existence for more than 30 days. Then they set its account to follow 30 users, far less, only 30 users, far less than the average numbers of account followed by a typical user, which is about 219. So it stopped the feed from being diverse, right? So it's only going to be a certain type of content. Now, all of these users were either already known for posting controversial content or were accounts for X's advertisers. That is, 100% of the accounts that Media Matters followed were either fringe accounts or were accounts for large national brands. In all, this tried to flood the zone and the account with only this type of content because they tried to create it. Like they tried to make it happen. But it didn't work. An internal review revealed that Media Matters, they started to alter its scrolling and refreshing activities, which is kind of scary, by the way, that they know this about you. Elon knows how many times I refresh my timeline. Oh man, that's not good. I don't want him to know that. I don't want anybody to know that. It's for show prep, honestly. Honestly, it is. But it's a lot, right? So, man, you're on Twitter a lot, Rob. All right, get a life, bro. So, scrolling and refreshing activities in an attempt to manipulate the inorganic combinations of advertisements and content. So they go right to their Media Matters account. They're like, oh, look what you're doing. And they can see they're scrolling. Okay, they're just scrolling, not even reading, scrolling, trying to see if there's any racist content, and refreshing. Media Matters and their excessive scrolling and their refreshing generated between 13 and 15 times more advertisements per hour than would typically be seen, essentially seeking to force a situation in which a brand ad post appeared adjacent to the fringe content. Now, eventually, through intentionally evading X's multiple safeguards, and by curating the content on its feed, and then repeatedly attempting to create the pairings of advertisements for major brands with controversial content, Media Matters finally achieved its goal. Accordingly, it took screenshots of the post that it engineered and then published it. Now, it hid its manipulation from everybody. They generated specific intended results that's not only inorganic, but exceedingly and demonstrably rare, all while taking the specific steps to obscure this fact. The overall effect on advertisers was to create a false and misleading perception. And Media Matters hid these manipulations and their omissions through selective secrecy. They omitted in its entirety its process of manufacturing these ad pairings. It did not include in its article that it created a user that only followed 30 accounts that either belonged to fringe figures or major national brands, neglected to tell us about that. Neither readers nor advertisers had any way of knowing that their entire feed was orchestrated to create the results. They didn't mention it at all. They didn't talk about excessive scrolling. They didn't talk about their refreshing. They just allowed users to believe that this is what happened. Totally organic and unmanipulated, all fake. Now, Media Matters also omitted and made no attempt to clarify the rarity of these pairings. The representation put forth by Media Matters constituted 0.000000909% of the impressions served on the day. Now, most or all of these pairings were not seen by literally anyone, besides Media Matters' own manipulated account. No authentic user of the platform has ever even been confirmed to have seen any of these pairings. And they tell us that Media Matters and their image choice in its smear also functioned to hide the true nature in its report. All images selected contained only the ad and the controversial content, with all of the other posts absent from the view. That is, if the readers had been able to see the posts above and below the pairings, they would have gleaned the highly specific nature of the small number of accounts that Media Matters chose to follow. Okay, you take a screenshot of your phone. You can see a lot, but what comes before and what comes after. But they just cropped that out to pair the two together. If you could have seen what came before and seen after, you'd be like, what is this person following? Why are they following this weird stuff? Now, Media Matters chose to show every pairing in its article using the same deceptive technique, hiding its deceit with even more deceit. Now, tellingly, Media Matters used X's privacy features in order to hide its methodology. They used the great features of X. That is, Media Matters set this account to private, so they blocked anyone from seeing which accounts Media Matters actually followed. Thus, they disallowed anyone from understanding how its feed was manipulated, so that if you tried to go search the story and see, oh, Media Matters is on this account, I wonder what this account shows, and you go try to find it, oh, it's private. Indeed, Media Matters at no point includes images with any information about the account that was exposed to these images. The cropped nature of the Media Matters screenshots leaves its profile picture out of the frame, so you can't even go look it up. But they found it, and it's private, so nobody can see it. So accordingly, they say Media Matters created the impression that these pairings were organic, accurate, representative of the typical user experience, which is not true, and that has demonstrably misled users and caused harm to X. Now, after the publication of the false smear, advertisers began pulling ads from the site, probably hundreds of millions of dollars, like no joke. Only happened after it was reported. Here are the companies that pulled out. Comcast, after Media Matters article was published, its parent company pulled all ads for Comcast. NBC, as the parent company of Bravo and Comcast, pulled all advertising. Apple pulled all of its ads. IBM pulled all ads. Media Matters was so severe that companies not even featured in the article pulled their ads. Lionsgate, losers. Warner Brothers, losers. Discovery, Paramount, Sony, losers. Says Media Matters did this with intent to harm the revenue stream. They represent themselves as a progressive research and information center, scam center, dedicated to comprehensively monitoring, analyzing, and correcting conservative misinformation. Now, since its launch in 2004, it has engaged in an all-out campaign of guerrilla warfare and sabotage on conservatives and conservative news sources, the worst. In this context, X and Elon are a critical Media Matters target because X, they say, is the most prominent online platform that permits users to share all viewpoints, whether liberal or conservative. And Mr. Musk is the most prominent voice on the platform, a passionate supporter of free speech. And so in taking down two forces it already found objectionable, Media Matters had the chance to starve X of ad revenue and thereby silence all of the voices on X. Nothing in Media Matters' campaign was coincidental or accidental. Its guerrilla attack on X is working, which we cannot let it succeed, driving away X's advertisers and revenue precisely as intended. And so Elon is under some fire now, obviously. They say here, interference with contracts, saying Media Matters intentionally interfered with the contracts between X and all of these companies, saying that they also are liable for business disparagement, saying that they made statements that are obviously untrue and disparaging, also interfering with their economic advantage. They describe this as reporting. It's not. It's deception. It's misrepresentation. It's wrongful conduct. It's bad faith. And they intended to disrupt these relationships. It's not truth information. It's like smearing. So X was harmed as a result of this action. It lost advertisers, and it has been a substantial factor in causing this harm because all of these relationships fell apart after Media Matters published their piece. And so they say here, X is asking for the following. 1, actual and consequential damages caused by Media Matters and their misconduct, including all damages. A preliminary injunction ordering Media Matters to immediately delete and take down and remove their article from their website. They want attorney's fees, and they want any action, other resources that the court deems just and appropriate, signed here by attorneys for the Elon team, John C. Sullivan and Judd E. Stone, on behalf of X Corp, suing Media Matters, and I hope they get every single penny that they ask for. And so that is not it. Elon is also joined by Ken Paxton, who submitted this. For immediate release in the aftermath of this scam story, Ken Paxton says that they are opening an investigation into Media Matters for potential fraudulent activity. The Office of the AG is opening up an investigation, says Ken, into Media Matters for potential fraudulent activity. Writing under the Texas Business Organizations Code and Deceptive Trade Practices Act, the OAG will vigorously enforce against nonprofits who commit fraudulent acts affecting the state of Texas. And Elon's in Texas now. Attorney General Paxton was extremely troubled by the allegations that Media Matters, a radical anti-free speech organization, fraudulently manipulated data on X. He said, "We're examining the issue closely to ensure that the public has not been deceived by the schemes of radical left-wing organizations who would like nothing more than to limit freedom by reducing participation in the public square," said Attorney General Paxton. And so, good news there in Texas. Elon is firing shots in court. So is Ken Paxton from the AG's office, and we're hopeful that they make some progress. Some reaction from Elon and others on the X platform. Elon said that Media Matters is pure evil. And this is a retweet of a Michael Schellenberger post that says the media is really, the goal is to destroy X. Okay, the media doesn't like X because they're getting all the attention. And Elon says they are pure evil. Man, Elon's a smart guy. This came over from Linda Yaccarino, who is the CEO of X. She says, "If you know me, you know I'm committed to truth and fairness. Here's the truth. Not a single authentic user on X saw IBM's, Comcast, or Oracle's ads next to the content in the Media Matters article. Only 2 users saw Apple's ad next to the content, at least one of which was Media Matters themselves. Says that data wins over manipulation and allegations. Don't be manipulated. Stand with X." And so I think that their response here has been quite good. Unfortunately, we've got a bunch of people who are hyper reactive to anything that scares them. IBM, Apple, Disney, all these people bailing when the propagandists seemingly have a victory. But we're seeing some people fighting back now, and Elon suing in Fort Worth, Texas, Northern District, out of a federal district court. And we'll be here to continue to follow the free speech battle because they did not have to contend with Twitter during the last election. X is now something they do have to contend with. And so the escalation will continue. We'll be here to continue to cover it, my friends. Thank you for subscribing. And thank you for liking this video wherever it is you're watching this. Don't forget to check out robertgovea.com. Sign up for our daily newsletter. Get access to this PDF and more. All the red lines are up there. And we'll look forward to seeing you on the next one. All right, my friends. Now, we've got one final segment on the day. And we're going to go through the Fani hearing and see what is happening here. Let's get this puppy queued up and make sure that the stream works, because that would be a problem if it didn't. Ooh, it ended up being 4 hours. And so let's get this queued up and get right to it, because Fani did not have a very good day. And she's unhappy about this. Fani Willis loses the bond revocation hearing in Georgia. She wanted to send Harrison Floyd back into custody, the same guy who was already in custody, saying that he broke the terms of his release by posting stuff on X. And this is Fani, who showed up in court to make arguments as to why Harrison should be thrown back in jail. And she lost, and she was not happy about it, man. At the end of this session, when the judge issues his order saying, all right, Harrison, we're going to just make some changes around your release conditions. We're probably going to gag you. We're probably going to make it so it's very clear what you can and cannot do, but you're not going to jail. Fani stood up and said, but Your Honor, there's going to be harm and blah, blah, blah. So we're going to listen to all of it. Today, the agenda is to go through the opening arguments, to hit the highlights of a couple witnesses, and to see what the judge's ultimate ruling is at the conclusion, because they were in session for 4.5 hours today. And just to get a layout of the land here, we're going to have the judge coming in on the top bench. You can see that this is another camera angle that looks like it is mirrored, but we see here, this is the prosecution's table, and this is the defense table. On the bottom left on your screen, we have here, this is Fani Willis, and this is Wade, the prosecutor. And then on the bottom right, we've got Harrison Floyd here looking sharp in the green, along with the two defense attorneys. And this is what it sounded like when court was getting started. We can see Fani is going to be walking up to the podium. Let's back up on this a little bit and tune on in.
All right, Ms. Willis, your floor is yours.
Floor is yours, Fani.
Good afternoon, Your Honor.
Opening statements.
I'm Fani Willis, District Attorney on behalf of the state of Georgia.
Now, real quickly, Harrison has already been in jail. He was somebody who got brought into custody, and they made him post bond in order to be released. Part of those release conditions is you don't talk to witnesses and other things that they're going to debate about. But he's been posting a bunch of stuff on the X platform, specifically tagging people like Jenna Ellis and others who are also involved in this case. We did a full video on this where Harrison was ordered, or Fani was requesting that he be brought back into custody. We read through her arguments. She's saying that he is saying things that she does not want to hear. And our response was, it's free speech. He has the full authority to defend himself and comment on a public case. That's the First Amendment. It's the same battle that Trump is going through, but a much smaller microcosm. And in this case, it's not the former president, right? Harrison has a lot less resources and a lot less Secret Service protection than Donald Trump does. And so the idea that a judge throws him into custody pretty quickly is possible, but doesn't happen that way. But this is Fani now saying his tweets are illegal. His tweets are harmful to our case. And I still think Fani's case is pretty weak, but this is what she says.
Just want to put some things on the record before we begin, and then the order in which we plan to proceed. We're obviously here because Harrison Floyd is indicted for 3 counts. One is conspiracy to violate the Georgia RICO statute, which, as you know, carries a penalty of 5 to 20 years. The second count is count 30 of the indictment, conspiracy to commit solicitation of false statements, a sentence that carries 1 to 2.5 years. And then finally, in count 31, influencing witnesses, which carries a sentence of 2 to 10 years. On August the 29th of 2023, a consent bond was entered in this case. And I know that that's part of the court's official record.
Yeah, they know all this.
The state contends that Mr. Floyd, the defendant that is here before the court today, violated 3 of the 7 conditions of that bond. And those are going to be conditions 5, 6, and 7 as outlined there. The state is requesting so that there's no mistake as to what we're asking, that his bond be revoked and that he be remanded back into custody for violating 3 conditions of the bond. I tell people often I think numerically, and so I often ask that people do that along with me. 3 is going to be a theme here. We believe, Your Honor, as we talk about Ayala and some other case law, that 3 of the factors he is a risk for, and that he violated 3 of the conditions of bond. I want to put some basic case law on the record, and if it's acceptable to the court, I'd like to be able to approach at this time and provide the defense with the first cases. And may I walk freely in the well, or would you like I ask every time? and the defense is now being handed Ayala versus State, 262 Georgia 704, a 1993
All right,
case.
fast forward.
228 Georgia
Fast
is more
forward.
likely to be true than not. And I will have to make sure my colleagues provide White versus the State.
All right, bunch of case law. Got it.
With that, I don't know if the defense has opening, but as you direct, we will call our first opening witness.
Mr. Morrison?
Good afternoon, Your Honor.
All right, cited a bunch of case law. We'll fast forward through all that. We know what the outcome is. So she laid it on the record. Got it.
One of the things I'd like the court to keep in mind is the spirit of this bond order, which was essentially to make sure that my client doesn't intimidate any witnesses or that he doesn't collude or with other witnesses regarding what their testimony may be. I believe when the court looks at the complained about tweets, you're going to find that that never occurred. It was never his intention either, Your Honor. I believe the court will look through and after it hears the evidence, will find at most, if he came close to the line, the court will have an opportunity to address that. I don't believe that he should be remanded back into the custody of the state. There's no need for that. One of the things that bothers me is if
And that's a good argument. Okay. What about warnings, right? Fani is like swinging for a home run right here. There was no warning. And we have some questions about free speech versus a politicized prosecution versus the, sanctity of the court and all those things. For example, right, what we had even in Judge Engeron's case, which is what we covered here, the New York case, when Trump was saying stuff that the judge didn't like, of course, that's a civil case, but he warned him, then sanctioned him 5,000, then sanctioned him 10,000, right? That's just one example. But wouldn't you get a warning? Wouldn't you get some clarity? Wouldn't you get some notice first? I mean, she's asking him to be thrown back into custody, and the judge hasn't even scolded him yet, hasn't even, given him like the first warning that you'd expect.
these tweets had so angered or bothered the state, they would have picked up the phone call and called the defense team of my client and said, hey, listen, he's making tweets. We don't like them. Can you do something about them? And we could have addressed the issue. Instead, they simply filed a motion.
Ooh, wow.
We believe the reason they filed that motion is my client is showing just how weak the case against him is.
Yes.
And I think he has a right to do that.
Yes.
This is political speech, Your Honor, and they're trying to silence it. Thank you.
Oh, right on. So shout out to that guy. Okay, so Fani had a little facial express. So as we're watching this, pay attention to Fani's face. She doesn't have a good poker face. So I think that's exactly right? And they don't like this. This is why Fani is overreacting. And this is the theme throughout this entire thing. Harrison Floyd is posting stuff that Fani does not want him to post about all sorts of other witnesses. And we read through his entire tweet thread, X thread, sorry, Elon, don't ban me, and explained all of the evidence that he was sharing. And so she's like, freaked out. He's got to go back into custody because he's wrecking their case by talking about evidence. And she does not want that to happen. Let me say this, commenting publicly about public evidence, right? Not talking about internal evidence about the case.
Say, call their first witness.
All right, call your witness, Fani.
Assistant Chief Michael Keel.
Okay, Chief Michael Keel. He's gonna
The law that regarding,
Well, he's about to testify, so I don't think he would need to go anywhere. But you're saying there's two other witnesses. The rules of evidence technically don't apply to bond hearings at all, including the rule of sequestration.
That's true.
But if there's anyone that would like to voluntarily step outside because they think that would be optically better for their case, they may do so. All right.
Okay, so the rule of exclusion of witnesses, you generally don't want witnesses to be in the courtroom listening to what other witnesses say, because then they can match their testimony to other witnesses, right? You want to seclude the witnesses from each other. So he says, well, this is a bond hearing. It's not really that.
Mr. Hill, sir.
would you like me to swear him in when you swear the witness?
I think we have Deputy Scott for that.
Okay.
Swear affirm to the testimony you should give a court today will be the
Yes, I do. Thank you, sir.
Please state and swear your full name for the court.
Yes, sir. My name is Michael, Michael, middle initial L, last name Hill, II.
Good morning, good afternoon, Assistant Chief Hill. Will you please tell the court where you are employed and what your title is?
Good afternoon, madam. Yes, I'm employed with the Fulton County District Attorney's Office. I currently serve as an Assistant Chief Investigator.
And in your capacity as an Assistant Chief Investigator, have you been assigned to work on what we'll refer to as the election interference case, the case that has us in court today?
Yes, ma'am. I've been so assigned for about 2 years now.
As a result of that assignment, have you had the opportunity to subpoena witnesses for proceedings in this matter,
Yes, ma'am, I have.
and also to interview witnesses in the matter.
Yes, ma'am, I have.
Have you also had the opportunity as an assistant chief to be familiar and aware with the social media pages, both of defendants as well as witnesses and victims in this case?
Yes, I have. That's correct.
May I approach?
While he's doing that, I just want to note for everyone, our court reporter is joining us remotely. So at any time,
Have you had an opportunity to look at 1 through 21?
Just a moment.
Familiar with exhibits 1 through 21?
I am.
Are you familiar with all of them in the same way?
Yes, ma'am, I am.
Okay, and can you tell the court how you're familiar with 1 through 21?
Yes, ma'am. So I'm familiar with exhibits 1 through 21 because they display the social media pages, specifically X, formerly known as Twitter, of defendant Harrison Prescott Floyd, as well as witnesses, Mr. Gabriel Sterling, and also Secretary of State, Mr. Brad Raffensperger.
Your Honor, at this time, we're going to ask that State's Exhibit 1 through 21 be admitted into evidence.
Your Honor, I'd ask the court to allow me to order the witness as to the foundation of these prior to accepting them as tendered and evidence.
you challenging the authenticity of these?
Yes.
All right. I'll give you some leeway there. Mr. Morrison.
Would you like me to do that now? If you would, sir, you're familiar with these exhibits, correct?
Yes, sir, I'm familiar.
Next to the name, there's a little symbol. Is that correct?
Yes, sir.
What is that symbol?
There's an @ if that's what you mean. The name of the page.
Blue check mark at the end of the names.
Is Harrison Floyd verified?
That first witness, Your Honor.
I'm not sure. Yeah, that'll be your question.
You may.
Is he verified on X?
Are you yourself a Twitter user, sir?
No, sir, I don't have any social media.
I see.
I don't
Okay.
use social media at all.
If I may, you'll notice here next to Harrison Floyd's name is what?
It's an American flag.
Okay. Next to Mr.
Shout out.
Sterling's, there's nothing. But if you look here, what is this next to Miss Ellis's?
Yes, that's the check signifying that her account's been verified.
But the account has been verified.
Correct.
Mr. Floyd's account been verified?
Well, according to your example, there's no blue check next to his name. So I would imagine that means that his account has not been verified.
Good call.
So
Good
have
answer.
you verified that these in fact are tweets, those which purport to be from Mr. Floyd are actually in fact from Mr. Floyd?
So you're asking in terms of my authentication or how I verified that these tweets coming from Mr. Floyd, or are you asking me to give you that answer?
Have you verified that they came from Mr. Floyd?
So the way that I verified, if that's your question, the way that I was able to verify that these are tweets that were, in fact, that came from Mr. Floyd, were for a few reasons. If you look at Exhibit 1, under Mr. Floyd's page, he has there's several comments. One's God's child. The next is Erica's husband. The next is Harlan's dad. The next is a U.S. Flag that says USMC veteran. The next is 2020 at Team Trump campaign.
So that's how you verified
And
it?
then the next is one of 19 defendants in Fulton County. And
anybody
then
can
lastly,
create
you'll
that.
see where it says, or
Anybody
underneath all that
can-
information, there's a location symbol, and it says North
Ah.
Bethesda, MD for Maryland. As a part of our investigation in this case, one of the ways that we were able to verify or actually able to state that, unequivocally this is his page, is that first and foremost, look at the second thing that I mentioned, Erica's husband. Mr. Floyd is in fact married to Miss Erica
Wow,
Damare.
this is their,
Um,
wow, okay.
The next is you'll see Harlan's dad. And then there's also a little symbol, an emoji symbol of a little girl next to
Okay.
Harlan. Not too long ago, Mr. Floyd and Mr. Damare actually just had a daughter, and I believe her name is Harlan.
So it's an emoji?
Also, next to that, where you see the U.S. flag, USMC veteran, Mr. Floyd is
Anybody
also a
can
former
create-
former Marine or U.S. veteran.
Yeah, so it matches,
Um,
that's fine.
Next, when I just stated the 2020 at
Hilarious.
Team Trump campaign,
Hilarious.
during Mr. Floyd's time, or defendant Floyd's time here in the state of Georgia, he was actually a part of and associated with, I believe, the president of Black Voices for Trump and a supporter of the 2020 Trump campaign. And then the last
Anybody
thing
can
that
create
I'll
a
state
fake
here is you
Twitter
see
profile.
one of 19 defendants in Fulton County. Defendant Floyd is in fact one of 19 defendants on this indictment.
Yeah, we got all that.
Okay, if I may continue, Your Honor.
Of
So
course.
you're
Yeah.
telling me,
Well,
Your
Mr.
Honor, I think we
Morrison,
could cut to
let me,
this.
let me just kind of cut to the chase here. If
Yeah,
you're trying
yeah.
to
Okay,
challenge the
Okay, so the judge, right, and this is what my thought was on this. Like, this is not a trial, okay? This is a bond hearing. And so it's not like the same thing that you'd expect at a trial. Like, they're not having to prove the evidence and all the, I mean, they might if the judge wants it, but the judge doesn't have to accept it. Honestly, the judge probably has his decision made, if I could be perfectly honest with this. Like, the judge is probably not going to come in and throw him in jail because that would be too overly aggressive. The judge is probably not going to say it's nothing. No, this is much ado about nothing. Fani, stop your complaining. Like, it was always going to be kind of splitting it down the middle. And I don't even know what the outcome is yet because we haven't seen it. But I do know he did not go back into custody. He's probably going to be gagged. We're going to hear what he says at the end. But this is like really technical evidentiary stuff. Like, if the judge doesn't want to spend all day doing this, and Fani does not like his answer because the answer is not any good. It's like, well, anybody can start an X account and put whatever information you want on there, and it's not. The real issue here is what can Floyd say? Like, ultimately, what can he say? Not about the custody of the X account, which I think most people would agree. We agree that it's Floyd's. But we're going to listen to a little bit more of this, and then we'll fast forward.
He's saying or reserve the objection that Mr. Floyd did not actually send these tweets or make them.
Well, hold on to that.
Is that what you're trying to do in terms of the authenticity?
I'd like to see the authenticity and the basis for these. I believe the state has the burden. I'm trying to hold them to their burden.
Right.
All right.
Good defense
And
attorney.
although you refer to this multiple times as posts by Mr. Floyd and the opposition's response. Okay. So we're going to admit them over the defense objection. And I think they've been tendered as posts that he gathered from Twitter. If you want to retain your argument that Mr. Floyd did not actually post these, I think that goes to the weight, not the admissibility. So we can continue.
And just while we were on that line, did you also see live images, videos, shall we say, from the handle that has just been referred to by the defense?
There
And
you
those
go.
live images, were you
There
able
you
to
go.
see defendant Harrison Floyd posting himself, giving live speeches, we'll say, from that particular handle?
Yes, Madam District Attorney, that was actually going to be my next statement. I have you live
sure it
feed
was.
or live video, if you will,
I'm sure it was.
posted on that Twitter handle.
Fani comes in with the assist. Hey, did you see him like repost live? Like, did you see which was the next? Any photographs, anything that can connect you to him, or is this just some profile that was created? So they get it. He's like, oh yeah, I was going to ask about that later. And so let's fast forward a little bit and talking about some of the posts. Okay, so we got the posts. We know where they came from. Now walk us through the posts.
This is a all caps cover up, and Fulton County is all caps corrupt.
There is an image on this particular printout. What is that image so that the judge knows exactly what it is he is looking at in State's Exhibit number 11?
Your Honor, that is an image of the body cam from the Cobb County Police Department of Miss Ruby Freeman at her home.
Let me ask you, do the basis of the initial charges in this case against Mr. Floyd, do they involve Miss Freeman?
Yes, they do, ma'am.
And to your knowledge, is Miss Freeman listed 40 times in the state's indictment in this case?
She is approximately thereabout, yes.
And is that surrounding the charges against this particular defendant?
Yes, it is.
So it's a related witness.
And
That's
this
good.
is an image from evidence in the case that is displayed on State's Exhibit number 11.
That is correct.
Now, can I just pause here and say respect to Fani for showing up in court and actually doing some questioning? Like, this is different behavior. This is new behavior, right? Jack Smith never does anything, right? He doesn't do anything. He sends it all off to Molly. He sends it all off to Jay Bratt. I don't know what he does, but he doesn't do anything. And everybody else handles it. And with Tishy Latish James, she does nothing, okay? If this was in New York, Tishy would be sitting where this dude is right here in the middle of your screen. Okay, that's like Tishy here. I don't know who this guy is, but that's where she would be seated. And Fani at least is making some argument here. Let's see where it goes. She's going to lose badly and be terrible at it, but let's see where it goes.
We move on to State's Exhibit number 12.
All right. We'll do one more exhibit and we'll fast forward.
Can you please put into the record what is displayed on State's Exhibit number 12?
Again, from the page of Mr. Harrison Floyd, this is a cover-up, all caps.
True. Fact
And
check, true.
Fulton County is corrupt,
True.
all
Oh, yep.
caps,
True.
with an
Perfect.
exclamation point.
Yep.
It is once again that same image of Miss Ruby Freeman at her home
Mm-hmm.
via Cobb County Police body cam. And underneath the image, it says, "So this begs the question, if Ruby Freeman didn't trust white people to help her, what did she say to the black people that offered to help her? I'll wait for you to get your popcorn."
Yeah.
Is there a
Good question.
response? And please do not put any profanity. I'd ask you to spell out the word that is profane underneath that comment.
Yes, ma'am. There is a comment. It comes from
It's a family
underneath
show.
this post, and the comment comes from at Full Ford Leonard. And the statement is, "Bury this BITCH under the jail."
Wow. Okay.
All right.
So that is a pure example of the heckler's veto, isn't it? So Harrison Floyd has a comment about this trial. He has a comment about corrupt Fulton County and how this is a partisan, political, weaponized prosecution against Donald Trump and everybody else who is in his orbit. And he makes a comment about it. And there is some other person on X who drops a response to that and says something about this BTC, whatever. And that is Floyd's problem, right? And this is Fani's argument. It's a heckler's veto. He should be gagged. He should be imprisoned because he said something that might cause some harm because somebody else posted a comment.
Right. Let's move on to State's Exhibit number 13. I believe the top of this post you just read, there is in this one a different depiction. Are there words now? And who is that an image of?
Yeah,
on
let's
this
read
post?
it. These are good posts.
Once again, it's, I'm sorry, you said State's Exhibit, which number?
I'm sorry, 13.
Okay.
Words in the, first of all, what is that an image of?
It is an image of, once again, Miss Ruby Freeman at her home via Cobb County PD body cam.
Okay. And are there words in that particular depiction that were not present in State's Exhibit number 11 or 12?
Yes, ma'am, there are.
Will you read into the record what those words are?
Those words state, "He told her that he wanted to help me."
Is there a comment beneath that in State's Exhibit number 13?
Underneath, there's a comment from at Brunettes are great. And the statement or the comment is, "Ruby should be in prison," with an angry emoji face.
Okay, let's move on to State's number 14.
All right, so they got 21 of these things. So we're going to fast forward through a lot of these and let's see where this picks up. And they're talking about a communication and somebody's walking around. And now it looks like we get into a little bit of cross-examination. So let's see what this sounds like. Looks like Fani is going to wrap it up right here. And here is where we go if we stop this circle of death.
Little weight that it would deserve.
So I don't have a copy of any of these exhibits, so I can't really speak to what's on it or what is not. But if there's any more you want to lay, and then we can revisit the objection.
So
Oh, he didn't have the exhibits? Derp.
what I've put in State's Exhibit number 23, how did you receive that?
So the contact that you just referenced with defense counsel for Ms.
All right, let's fast forward.
Issued. Thank you.
So that we're clear for the record.
Today, Tuesday, November 21st, 2023,
And at what time?
this morning at 10:59 a.m.
And this was, again, he spoke this to you verbally
Yes, ma'am, that's correct.
and then memorialized it.
Yes, ma'am, that's correct.
Your Honor, at this time, I would ask that State's Exhibit number 23 be admitted for purposes of this hearing only, and that he be allowed to read it into the record and that it be admitted.
All right, Mr. Morrison, you renew your objection on authentication.
No, Your Honor.
All right, exhibit 23 is admitted.
Can you please read it for purposes of the record?
So in the message, Ms. Jenna Ellis states, "I saw it a couple days after it was posted. Yes, I believe it was meant to both intimidate and harass me, and also encourage others to harass me, which
That's Jenna Ellis's statement.
others have done in the comments and separate posts following this post, and Floyd's comments about me on media." And then there's in the parentheses, which the DA references in their pleading.
One moment, Your
Wow.
Honor.
So that sounds like that was Jenna Ellis's statement, meaning she wants Floyd in jail. Let's just make sure that we can confirm that, because I don't want to be unfair to Miss Ellis. So this is being admitted, and it is Jenna Ellis's statement.
Saw it a couple days after it was posted.
It into the record, it.
Yes, ma'am, that's correct.
At those, so there was a moment and open up
I think I left it.
it via this. You received it through him verbally telling it to you, and then he memorialized it via this text message.
That's correct.
And for purposes of the record, was this sent to where?
It was sent to my Fulton County issued cellular device.
Do you have that with you?
I do.
Do you have it on you now?
Sent to my Fulton County.
Let me ask
Today, Tuesday, November 21st, 2023.
And at what time spoke this to you verbally
Yes, ma'am, that's correct.
and then memorialized it?
Yes, ma'am, that's correct.
Your Honor, at this time, I would ask that State's Exhibit number 23 into the record and that it be admitted.
All right, Mr. Morrison, you renew your objection on authentication.
No, Your Honor.
All right, Exhibit 23 is admitted.
Can you please read it for purposes of the record?
So in the message, Ms. Jenna Ellis states, I saw it a couple
Wow.
days after it was posted. Yes, I believe it was meant to both intimidate and harass me, and also encourage others to harass me, which others have done in the comments and separate posts following this post, and Floyd's comments about me on media. And then there's in the parentheses, which the DA references in their pleading.
Wow.
One moment, Your Honor.
So Jenna Ellis sent a message into the court saying that she thinks Floyd is harassing her, and that this statement should justify him going back into custody. So just so we're clear about what Jenna Ellis is doing, she wants Floyd back in custody because he was complaining about the corrupt Fulton County. That's amazing. And how many people donated to her for this one? Hundreds of thousands of dollars to her. And now she is supporting Fani in her imprisonment of other co-defendants? Wow, Jenna, wow.
Your investigation on Mr. Floyd, does he have other names that you're aware of?
Yes, Willie Lewis Floyd III is another alias for Mr. Harrison Floyd.
Does he also have in your investigation other open criminal charges?
Yes, ma'am, he does. In particular, federal charge for simple assault against two federal officers.
Your Honor,
Another further, for the
specifically, that's not a matter that was raised in your motion to revoke the bond. Bringing it up here and now, that's the basis upon which they asked the court to rule, would deny my client procedural due process by springing it on him in the middle of this hearing.
All right, well, Mr. Morrison, if that's a line of argument that you think you need more time to respond to, and you need to articulate how that extra time
So the judge is just indulging here a little bit.
you can do that, and we'll go from there. All right, I think it's Mr. Hill's up for cross-examination.
All right, we'll listen to a little cross and then we'll go to the next witness.
No, that's not correct.
That you're not familiar with social media.
No, sir. No, that's not correct.
Well, you're not very familiar. You don't use social media.
In my personal life, no, I do not.
Understand. Now, you said that these are direct communications, is I believe how you characterize that. Is that correct? May I approach, Your Honor?
You may.
I'm going to hand you what's labeled as Exhibit B for the defense.
Yes, I'm familiar, but you just said that I characterized something as direct communications, and I didn't. I didn't say that.
Okay.
Yeah, I don't know where you got that from.
All right. So perhaps you didn't. Perhaps it was the motion of the state. But there is a mechanism in Twitter, or now what's called X, for direct communications, direct messaging. Isn't that correct?
Sure.
Okay. And this is an example of how one would use that app to directly communicate with someone, should they choose to do so.
It appears if you want to send someone a message similar to an email or a text, you could do so via X or Twitter.
Okay. Were any of these, what you call messages, conveyed in that manner?
I'm sorry, I don't understand your question.
Or was this messaging, this direct messaging used by Mr. Floyd to convey messages to any of these witnesses or co-defendants?
I don't have any evidence of that, no.
Is the answer no?
I don't have any evidence of that.
Okay,
He
so,
may have, I don't have any evidence of that.
okay, so you can't say that they did.
I can't say that he
In
did.
fact, all of the messages and exhibits to which you referred to, that isn't the mechanism by which you contend a message was sent to any of these people, is it?
I'm sorry, I don't understand your question, sir.
Okay. The message, the mechanism by which you say Mr. Floyd communicated with people
Yes,
was by putting the ampersand in front of their tag.
correct.
Isn't that really how you reference people?
Well, in the instance of what we're discussing today, that's how he referenced and how he communicated with people.
Well, I mean, when you reference someone, what does that trigger? What happens? I put an ampersand in front of someone. Do they get an email with the message contained inside?
So one of the witnesses in this case, and I think this will answer your question. One of the witnesses in this case, when I spoke to him about the one of the symbols or when he added them on X, it was conveyed to me that although he did not get the instant notification because he does not have that setting on his cellular device, once he looked at his notifications via his Twitter or X, however you want to reference it, he did see all of the ats that Mr. Floyd continuously utilized.
Now, I noticed that when you look at Exhibit 12, do you have those exhibits in front of you?
Yes, sir, I do.
Okay. This is referencing, and it's repost, it looks like it's 11 seconds long. What is this? Where did this footage come from?
As I mentioned earlier, this is the body cam footage from the Cobb County Police Department, evidence in this case of Ms. Ruby Freeman at her home.
Well, this is in public domain, isn't it?
Well,
It's body
Can
cam
you-
footage?
can you- yeah, can you ask your
Videos
question again?
have been released to the public.
some of these videos I have seen in public articles and news media. I have.
Or are there any of them that you haven't? Or are there any of these that you could say are not in public domain?
None of the videos that we've observed today. No, sir.
So they're all public domain as far as to your best knowledge and belief, correct?
Sure.
Okay, great. So he has the free speech rights to comment upon those things. Now, let's fast forward and get into the next witness. You can hear this guy is brought in. And so let's get started with him. You see, this gentleman is going to be in the bottom right of your screen. And let's pick back up and see what happens.
Yes, ma'am. As a Georgia Secretary of State.
Where are you employed?
The Office of Georgia Secretary of State.
All right, and have you had an opportunity did you have an opportunity to testify at the special purpose grand jury?
Yes,
in the
ma'am.
matter that brings us here today?
Yes, ma'am.
I'm going to show you a couple of exhibits that have already been admitted into evidence. I'm going to ask you some very brief questions on them. Are you familiar with State's Exhibit number 2?
Yes, ma'am.
Okay, and just for purposes of the record, if someone tags you at gabrielsterling.org, do you in fact receive those? If they tag you here, then I'll go back and ask about that.
GabrielSterling.org is my old website. I think you're asking
I'm
about.
sorry,
my-
at
yeah.
Gabriel Sterling, yes.
Yes.
Okay, and also, if someone tags at Georgia Secretary of State, is that something that a member of the Secretary of State's office, to include you, would receive?
Yes, ma'am.
Okay, and moving on to State's Exhibit number 7, have you in fact seen this post? State's Exhibit number 7,
Yes, ma'am.
and is that because you were tagged at Gabriel Sterling?
Yes, ma'am.
Moving on.
Okay, so we get the point, and the nose is whistling in our ears. So we get what they're trying to prove, right? The idea is that they got noticed. So when Floyd tagged them, boom, it showed up on their account. They got it. Now here's a little cross-examination.
Number in there to show you new things that have happened since the last time you were there, and then you would go to that and you would see things where you were tagged in. Yes, sir.
A notification.
I don't know if you have State's Exhibit 7 in front of you.
I have nothing in front of me, sir.
Your Honor, may I approach briefly? It's our seal.
Reserves.
So that post could be talking about that case,
I don't know what Mr. Floyd said, sir.
right? We don't know what case this is referring to, do we?
Not particularly. No, sir.
May I have it back?
Yes, sir.
Okay. So he comes and talks about X. Probably not much more.
Ms.
from
Freeman
him.
and her daughter, and what is her daughter's name for purposes of the record?
Here's another witness. This guy's brought in. Fanny's questioning him.
Her daughter is Shay Moss.
You also represent Ms. Moss?
I do.
Is Ms. Moss a witness in this matter?
Yes, to my understanding.
And in fact, have you accompanied them to proceedings in this matter?
I have.
Why did you hire this company to do threat assessment on your two clients? Is that something you do for every client you have?
No.
Why did you find it necessary to do for this particular client?
Well, just the level of threats since all of this began for Ruby and Shay have been quite high. She's been listed on death lists. She's been told that she needs to leave her house by the FBI. So we just need to keep an eye on what's out there, whether there are any spikes or flashes in the threat level. So this company has been retained to do that.
And in fact, the threat levels at one point prior to this matter were so high, she had to relocate from her home.
Absolutely.
And that was on the recommendation of the FBI.
Yes, it was.
Prior to the state contacting you, were you made aware of some comments by a defendant in this case on social media?
Yes, I was.
Harrison?
What defendant were you aware of making comments as it related to your client, Ms. Freeman, prior to the state ever contacting you?
Mr. Harrison Floyd.
How is it that you became aware that Mr. Floyd, the defendant in this matter, was making comments about your client?
Well, a couple of my co-counsel informed me that there were some comments being made and that we needed to huddle together and have a
Co-counsel.
a session to assess what was going on and to determine whether there were
Why did co-counsel?
any measures that needed to be taken by us or by Ms. Freeman and Ms. Moss
To keep them safe.
to keep them safe. Absolutely.
And in fact, as a result of these comments made by Mr. Floyd in relationship to this matter, did you call what you referred to me as a spike?
Yes.
Can you educate the court as you educated me as to what a spike is and why that may cause you some concern as well as the other team that represents her?
Sure. So a spike is simply a time at which online activity regarding Ms. Freeman and her name is mentioned at a particular time. And you can tie spikes in this report to actual posts and things of that nature. So I believe this is the report that tied
She's
a
trending.
particular spike in that online
Okay,
activity.
we got it. She's trending. We got it. Now let's see what else is happening. So we see we have a big break here. Okay, so that guy wraps up here. He says, you know, I'm an attorney for Ruby and everything is dangerous because these guys post. Let's see what's happening right now.
Mr. Floyd's comments reaching these witnesses just that it was improbable.
It was improbable, yes. It could, surely they could see if it shows up in their feed, surely they can see it. But that's the other thing. Were they talking about the facts of this case? And I can go through each one of the Twitter posts that
Well, it says that they can't communicate, right?
not just communicate, can't communicate about the facts of this case.
And so, for example, with the one with Miss Ellis, how would that not be a communication about the facts of this case if it's solely referencing a proper session?
Because first, it's public in the public domain, number one.
The video.
Well, that wasn't a precondition, right? Of the bond
No,
order.
but she's not, I'm just pointing out the fact that her video is in the public domain. He's commenting on the video. It is a public comment. He's allowed to do that under the First Amendment.
Right. Same thing as
So
Trump.
the idea that this is somehow not a permissible communication, it's a problem because that begs the question about the facts of this case. What facts? The ones as they develop, the ones that are ongoing, the facts in the indictment, I mean, which also spurs another question. Miss Ellis won't even be a witness against us. I mean, I know that the state's going to say, well, she's a RICO witness. We don't have anything to do with Miss Ellis. Not only that, we don't even have a witness list. All we know, we have
Look at Fanny's
unindicted
face.
co-conspirators. We have to guess who the witnesses might be. Now, the state has said that they have sent us discovery, but that discovery is like a football field sized haystack about 10 feet high and we're looking for
Yes.
5 needles in it. I have to go through 30 or 40 folders and click down only to find out that the file that I'm looking at is a GIF image. So the idea that, well, we've turned it over.
GIF or GIF?
I don't know if they've turned it over. I had to search. I had to ask the other day for one of the witnesses' grand jury testimony that they said they had just received.
Sounds like
So I don't know
Chutkin's
what the
courtroom
state
in
has or what they
DC.
don't have. I don't know what who their witnesses are. I don't, that's of no concern to me.
Sure, but I think you have a pretty good indication of who they're going to be, at least some of them.
I didn't know Gabriel Sterling was a witness. Had no idea, Judge.
No idea.
Zero.
Wild.
But what about the Secretary of State?
Right, but that's also a public account. He's not barred from calling out the Secretary of State. Now, if we don't like that, we should change the bond order.
Exactly.
I would submit, Judge, that would be the
Don't
appropriate
throw him in
remedy.
custody.
The
It's a
state
warning.
surely, and you read my motion, the state, or my opposition rather, the state knows how to address social media posts as it did with President Trump.
Yeah, we've already done
so,
this. Oh man, that
you-
is good. That is so good. We've already done this. We've already been here. Okay, social media posts, gags, all this stuff. Fani way overshot, man. She was coming in here hot. She got all done up and everything. I'm coming in here and I'll show the media. And invites everybody into the courtroom, and she wants to throw him back in custody for social media posts. We've already been here. We've already done this. We're like on our 3rd season now of gagging Trump. It's the same story.
Again, this idea that someone has pleaded guilty and an explicit condition of their plea is that they're going to be a cooperating witness. You still don't think that's sufficient notice that that person's going to be a witness in the case?
No. I stipulate. So we're clear on the record. She's a witness in this case, not against him.
Yeah.
Well,
she's a-
So what he's saying here, right? The RICO indictment is so big that it has like different chapters of criminal conduct. And so, for example, the Sidney Powell, Jenna Ellis, I think Jenna Ellis is she in the same batch? I don't want to overspeak, but for example, Sidney Powell, okay, the charges for which she pled guilty don't mention Harrison Floyd at all, right? They have nothing to do with Harrison Floyd. It's like a totally different week. It's a totally different chapter of the book. It's like totally unrelated. So yeah, Sidney Powell can come in and talk about her tiny role, but she like literally can't point the fingers at Harrison because the conduct has nothing to do with him. For example, Sidney Powell, we know that she was really originally indicted for hiring the third-party expert witness to go and do some analysis, which is what lawyers do all the time, by the way, is hire third-party people to do it. So she pled guilty through a guilty plea proceeding, which, by the way, is going to ultimately be dismissed as long as she completes diversion. She will not have any conviction at all. But he's saying that her conduct doesn't relate to Harrison. So, okay, she's a witness, but not against him.
She's a witness in the prosecution against him. He's going to be sitting presumably at one of many tables, and it will be
But
in the
nothing
state's
that
case in
comes out of
chief
her
where he is a
mouth
defendant.
will go against Harrison Floyd.
I may be presumptuous in thinking that won't happen, but Judge,
Oh!
she's a witness to be sure.
Did you hear what he said? He thinks this case is crap too, just like we've been saying here for months now. I'm presumptuous in thinking that's not going to happen. This trial is not going to go. The reason Fani's here right now is because this is her big debut, right? This is her, I'm playing hard. I'm going to put somebody in jail because she has no case. Okay.
But nothing in that bond order prohibits him from contacting a witness. Nothing in the bond order prohibits him from contacting a co-defendant. They just can't contact each other about the facts of this case.
Very
They could
narrow.
call him and say, hey, you want to come over for dinner tonight? As long as we don't talk about the facts of the case, they can do that.
Come on over. It's
That's why I
Thanksgiving.
pinpoint those words.
See you here in a minute.
Communicate with. That's the other part of this. It's not simply to shout out into the Twitterverse. That's like going to Mercedes-Benz Stadium and being on one side and Miss Ellis is on the other side and during the middle of an Atlanta Falcons game. And he yells out, hey, Jenna, give the money back. If she happens to hear it, and maybe the crowd starts chanting, give the money back. She's
Jenna,
a public
give the
figure
money
as
back.
well.
Give
A
the
million
money
followers,
back,
Judge.
Jenna.
A million. She wasn't.
Give the money back, Jenna. That's his example in court. Oh my gosh. That is so hilarious. He could be, did you hear what his hypothetical was? I can't even believe how brilliant that was. Your Honor, for example, we could go and scream in a football stadium, give the money back, Jenna. Give the money back. And maybe she'll hear it. And maybe she'll return the money, but probably not.
Hear it. And maybe the crowd starts chanting, give the money back.
Maybe the crowd wants her to, too.
She's a public figure as well. A million followers, Judge. A million. She wasn't worried. She didn't know anything about it. She didn't reach out. So we're not contending that she's not a witness. The thrust of this is collusion. Are you getting together with other witnesses to change stories? I don't see any other purpose for those paragraphs 6 and 7. So I would submit, Your Honor, if we pay attention, if we're faithful to the text of the order, paragraphs 6 and 7 are clear. Communicate with, not communicate to, not say something about, because that's what this really amounts to, say something about. You heard
Love it.
Assistant Chief Hill. I believe his testimony was he didn't know what was in the mind of Mr. Floyd. Mr. Sterling contended that one of the posts, or he agreed, one of the posts he wasn't even sure what case it applied to, but he knew there was another case pending that had sealed ballots in it. So yes, when you're tagged, it shows up in your feed. But like I said, Judge, you're not required to, it's not a requirement in Twitter. People post, I post things all the time where I will put an @ symbol. Do I think that the other person might see it? It's possible. I don't care. I want to post. It's a political forum. That's the whole purpose of ideas. I mean, you don't,
True.
that you find something offensive, you don't have the right not to be offensive. I mean, in order to think, you have to risk being offensive, do you not?
So, yeah, just taking that point, I just want to focus here. I think maybe the Twitter aspect of this may be confusing it, but what would be the functional difference of Mr. Floyd having just written a letter and mailed it to him and assuming that Miss Ellis gets 1,000 letters a day?
Because that shows his intent. His intent is to make direct contact. There's a mechanism in Twitter for direct notification, direct
Nice
contact.
job. Nice job.
You can send a message directly to
DM
the
her.
person, as opposed to the Twitterverse, the forum, the public forum, putting out a political message, a political opinion. He can do all of those things. He can say, you know, I'm innocent. I didn't do this. Now, is he talking about the facts of this case? Well, I'm sure the district attorney will try to use this stuff at trial, perhaps. But Harrison Floyd has never said that anything against Ruby Freeman. And by the way, Ruby Freeman doesn't even have a social media post. And I want to bring this report up. I would encourage you, Judge, look at page 2. A majority of these mentions related to commentary about the latest post from the Gateway Pundit regarding Ms.
Shout out.
Freeman and Mrs. Moss's alleged participation in election fraud. Her attorney said this report was about his posts, but I don't see how you can compare the two. Gateway Pundit has a slew of followers. His Twitter account is 25,000 people, not 2 million, not 3 million, not the million that Jenna Ellis has, not the 75,000 that Mr. Sterling has, or the 114,000 that Miss Willis has on one of her accounts, and however many others she has on her other account. A lot of this has to do with being in the public domain as well. Nothing in any of the posts that he wrote about Miss Freeman show any threats of intimidation. They are merely statements that he is claiming, I'm innocent, I haven't done anything wrong, which is why I said in my motion, or my opposition rather, that this court should be faithful to the text of the bond order. If we have an issue with it, Judge, we're very amenable.
Modify it.
You heard my co-counsel say earlier, all they had to do was call us. Mr. Floyd has come back to Georgia voluntarily. The first time when he turned himself in, he was put in jail, wasn't able to get a bond hearing until Your Honor got involved. You got back and were able to get him a bond. He appreciates that immensely. He came back today just because I told him to. He's a law-abiding citizen. Yes, there are some other things pending, but that has nothing to do with this hearing. Zero. If the court tells him, look, I want you to tone it down, I don't want you to mention Ruby Freeman, he'll do what you tell him to do. It's not that at that point, it's not about a First Amendment argument. We'll let that go, Judge. If his rights to speech are in jeopardy versus his freedoms and liberty,
Yeah.
his personal restraint, Judge, he's going to opt for his personal liberty. So I would submit, Your Honor, that this whole tactic
Just tighten it up.
is somewhat of a retaliation. If you look at when the motion was generated,
Exactly.
I believe the motion was generated on the November 15th, just
Yep.
after this court's hearing, because we received it 2 hours after the court's hearing on the protective order. Miss Willis was in DC. She personally signed the motion, or they
She
put
did.
her signature on it.
We noted that.
She was attending an event with a women's
yeah, she's
summit,
very interested in this
and
case.
also a fundraiser.
Very curious about this.
But the reason why I say it was cobbled together hastily was because Jenna Ellis's post is on the 13th, and she says,
Exactly.
She saw it a couple of days later. Well, I would submit, Your Honor, that
Fani got
she was
freaked.
raised, the awareness of that was raised to her by the state.
She knows her
I
case
just don't see a million followers
is
how that could
leaking
happen.
out.
And so with that, Judge, I would
So
just
she's
check
trying
one
to get
thing here.
protective orders in, and she's trying to put him back in custody because she is freaked out. Like the evidence is leaking, and she shows up in court like on her own to try
Yes,
to
and there's
salvage
also
this.
on Twitter, if there's a post that's found offensive or threatening, it can be reported.
Report it.
And
We'll
people should do
remove
that. If
it.
they want to generate reports, they can. But it would be just as effective to call out posts and say these are inappropriate posts. So with that, Judge, I conclude.
All right. Thank you, sir. Nicely done.
State be heard. Your Honors, I always like when me and the defense can agree. We agree on something. We just ask you to strictly rely on the order that you sign. And as Your Honor knows, I only have to prove he violated this order one way, and that would be enough to revoke his bond. So I'll lead you to number 7 that says the defendant shall not communicate in any way directly or indirectly about the facts of this case with any person known to him or her to be a witness in this case, except through his or her counsel. It's clear they signed it, they understood it. Now I'm going to take some time and go through a PowerPoint. I didn't ask any questions today to offend you. I asked you because of the absurdity of their argument. My team asked me to tone it down because I referred to it initially as lunacy, and they asked that I refer to it as absurdity. I would submit you can use either adjective. Put it up. I need a screen share, Your Honor.
Wow, she's fired up. All right, let's listen
Which
to a little
which
bit.
account is joining to
What account is
host,
joining?
Mr. Wooten?
It's under my name, Judge.
All right, just one moment.
We got a PowerPoint.
We can go back and
To commit solicitation.
All right,
And
we're not
count-
going to do Fanny's PowerPoint. All right, thank you for your PowerPoint. Great, got it. So let's see where this goes. Let's see if she's done with her PowerPoint. All right, more PowerPoint. We got it. Fanny, can you just make your argument, please? The other guy didn't use a PowerPoint. Is she done? Did she? Is that it?
Demand to intimidate witnesses. We use an election worker. Continue to do is exactly what the defense asked you to do. Read the court order.
And
Look at the
slideshow.
evidence. He violated this court order.
Stop sharing your
It is
screen.
unfair to those witnesses that are just coming, first, to do their public duty as an election worker, and second, to do their public duty as a witness. And there are real consequences for allowing defendants to intimidate witnesses. Your Honor, we're asking that his bond be revoked and he be remanded today.
Wow, Fanny. Wow, she's fired up.
I'm going to allow the state the last word, but Mr. Kasparov, if you have a few other points you want to make.
Yeah, I'll be brief, Your Honor. Your Honor, as you know, I've not ever contended that Miss Ellis isn't a witness or that we didn't know she was a witness. I'm not sure where that came from. My motion said, our opposition says she was a witness. We admit that.
He's saying
The state's argument is
against
that
our client.
anything on social media posted about, that Harrison Floyd posted about this case is automatically an indirect communication, if not a direct communication. That's absurd. And that's where we're running into trouble here. Judge, I would submit you focused in on one particular tweet, which was Jenna Ellis. And I want to go back to her tweet. That tweet is a shout out to the Twitterverse at large. Yes, I think it walks up close to the line, but if you understand the world of Twitter, or X as it's now called, that's not how people communicate.
Don't ban
It's a
him,
very
Elon.
ineffective way to communicate. If he really wanted to communicate with her directly, he would have simply sent her a notification and called her a liar or whatever. And he could have even called that out. That would have been a clear violation of the protective order. The other point that the district attorney made was that, oh, we said we didn't stir the pot. Yeah, we didn't stir the pot. You see, the district attorney stirred the pot. They've been stirring the pot since he got arrested.
Ooh,
Judge.
Fanny's turning her head.
From the very first occasion, I never got a call about Mr. Floyd getting bond. Rather, I have Miss Willis and Mr. Wade apparently recorded my colleague up in Maryland, which, by the way, it's a two-party state. It's a felony to record without permission up there.
Oh,
They recorded
Fanny!
my colleague, and he said, I don't know anything about the bond. I was handling his case to come here to Georgia. So this idea that he's been given all these chances, et cetera, I think that's hogwash.
yeah.
Now, this idea though that we didn't stir the pot. All the evidence that you have, the views, they are wholly dependent, Judge, when they were captured, when you looked at Twitter and when you captured that image. When they filed this motion to revoke bond, Just like when they filed the motion for the protective order, if you recall, Judge, I was in court and I said we had gotten numerous calls from the media that they were pestering us, and you said, well, we should all expect some of that. And I agree, we should in this case.
But Fani
But this
blamed
is,
him.
this is not exactly right, because when they file a motion to revoke his bond, they're all in the back watching us. When they file the motion, it immediately causes a spike and everybody starts searching everything. So they can't use that as evidence against Mr. Floyd.
They're making
I
claims
think
about
that
him.
is absurd.
Okay, so let's fast forward and let's get to the judge and let's hear from the judge, because we still want to close out with some opinion. Now, the judge is going to say, I'm going to take a break and think about all this, right?
About the facts of this case, as I want to express to Your Honor one more time, it's not that he can't talk to a witness or a co-defendant. What Ms. Willis said about that is absolutely incorrect. That's not even what the court order says. The court order is specific. You cannot talk to another witness or co-defendant. You cannot communicate with them about the facts of this case. The whole
And he didn't
purpose
do
of that
that.
number 6 and 7 is to avoid collusion. That didn't happen here. What we have here are First Amendment issues. If you want to curtail, I would submit, Your Honor, we should adopt what the president's bond order, bond conditions, where they explicitly mention the First Amendment issues on Twitter, because the president is known for that. So if they felt that this was included in his bond motion, they should have put it in there. They had the opportunity to do that. Thank you.
All right, over to the judge.
I'm not gonna be long. The bottom line is the defendant didn't respect the order of this court. He violated it. If you have questions about intimidation, don't go to that paragraph. Go to paragraph 7. Although you have a witness, Ms. Jenna Ellis, telling you she felt intimidated, and Von Du
Wow,
Bois, who
Jenna.
represents
Wow.
another witness, telling you that he interpreted, that his team, to include his client, interpret that as intimidation. But you don't need it. All you need is paragraph 7, which says he's not to communicate. This notion that tagging someone doesn't get a message to them is really lunacy.
Woo! All right, so Fani, now the judge.
All right. I'm going to compile my notes and I'll be back in 5.
Be back in 5 minutes. I think it takes a little longer than 5 minutes, but all right, they're waiting around, still waiting. We fast forward. Judge is
While
back.
there may
Judge is back on the bench.
others to speak his mind. Another.
Okay, now we're getting close to a ruling, and I heard a noise. Is the judge coming in? People are getting a little antsy. I see him turning the corner.
Man, seated.
All rise. Okay, please be seated. Judge is back for a ruling on the motion.
All right. Thank you all for your patience. So just a few thoughts to share. And the first, I would just say how we got here. At the outset, I'll just note that at the time of indictment, we were in this courtroom in the middle of another murder trial, so I was not able to conduct the first appearance for Mr. Floyd. But throughout that week during the trial, we were presented with these consented bond orders, which were negotiated by the parties, and that I signed without a hearing. And Mr. Floyd agreed to abide by the terms of it. And I think it's clear from the case law, there is no constitutional right to bail.
You
And a bond can
see
contain special conditions as long as they're reasonable under the circumstances.
intensity on the
And
faces.
often those can curtail or even eliminate defendant's constitutional rights under the First Amendment, under the Fourth Amendment, such as forbidding contact. We see that quite commonly. And the question becomes, a trial court has to balance the rights of the accused, as well as the public safety interests that are raised by any particular case. But I'll also note that a defendant is generally allowed to publicly criticize the merits of a case, to say that the prosecution doesn't have a case, to challenge the strength of the evidence, to speak his mind. And I don't see anything in this consent bond order that limited general criticism of the state's case. Each of these conditions had components to them, had preconditions, but there was no general limitation of talking about this case. But obviously that criticism cannot cross a line and ever evolve into witness intimidation. And I think, as the defense was willing to concede here, Mr. Floyd seems very boldly willing to explore exactly where that line lies in this case. And I think the state has made a compelling argument on many of these points. But in categorizing these statements,
Here it comes.
on the first point of intimidation, we don't see, as we might see in these bond conditions, as they're traditionally understood, someone posting the personal info of a witness or a co-defendant. We don't see someone directly messaging, again, as that's traditionally understood. And we don't see in the wording an explicit indication that something ought to be done about these individuals or that they should be targeted in some way. I read these as seeing more that someone is wanting to defend his case in a very public way.
As is his right.
And
Under
so
the First
on the
Amendment.
question of, and especially when it comes to the public officials, I think we've, as Mr. Sterling testified, when it comes to intimidation, they've endured far worse than is presented in this motion.
Obviously.
I think it becomes a much closer question when we start talking about whether this is direct or indirect communication. And we're getting into also kind of a question of at what point is someone responsible for the response of others?
Yeah, the heckler.
And I don't know if those are necessarily settled questions
They're not.
under the traditional bond limitations that we used and the phrasing that we used in this case. And
Come on, Judge. Come on.
ultimately,
Come on.
I think that,
Do it.
first of all, the defense argument that there's no knowledge that these were potential witnesses. That's not an argument that I'm buying. I think that we can't hide behind a veil of ignorance when certain witnesses have testified before the special grand jury or are very much known to be involved in the
We're
facts of this
getting
case,
closer.
or just recently pleaded guilty and were known to have a public cooperation provision. I also think that when we're talking about the facts of this case, that is a broadly understood term. And if someone is just denigrating another person who's known to be a witness and talking in reference to their proffer, that's also satisfying that precondition.
Stop
But
teasing
when it
us.
comes to the question of indirect communication, again, I think it comes down to, while there may, I do think that in several instances here, there has been a technical violation of Mr. Floyd's bond, and
Oh.
that communications he made wound up before the eyes and ears of potential witnesses and co-defendants.
But
But
Ooh.
not every violation compels revocation.
Oh,
And so I am stuck on the question of notice, and that the bond conditions as written in my mind were not specific enough to account for the nuances of social media. So I think the ultimate result of today's hearing is that it's very clear to me that this bond needs to be modified.
Oh.
And I think it needs to specifically prohibit any public comment concerning Ms. Freeman,
Not revoked.
concerning her daughter, and
Modified.
concerning other witnesses that need to be included, because even if he's not directly or indirectly communicating with him, however we define that term, I think the public safety interests raised as a result of today's hearing indicate that his actions have a consequence. And because he's under the conditions of this bond order, the court has the ability to curtail and protect that interest.
Sorry,
So-
Fanny. Womp womp.
Ultimately, what I would be asking for is for a recommendation from the state, but I would also allow the defense to respond of exactly how they would propose adding or modifying these bond conditions. And I will then take those under advisement and enter a modification on the record. And nothing from today's hearing should be seen as curtailing the state's ability to refile such a bond revocation motion immediately upon an additional violation. And I think that it also is very much dependent on the specific facts of the tweets and communications at issue here. And it can't be so broadly defined to cover all other co-defendants.
All right. Sorry.
So on the
Fanny.
issue of modification, I think that's something that we can revisit and let time to consider, unless there's something the parties would like to address
Let's hear
now
it, Fanny.
and want the court to be able to consider
Let it
specifically
out.
what they would like to see as a modification. or
Let
that's
it
something we
out.
can follow up, but the court is available and ready to enter that as soon as it's conveyed.
Here's Fani.
Anything, Ms. Willis, that you would like to add?
Oh yeah, she's mad.
Obviously, we're very concerned about the safety of Ms. Ruby Freeman. She has clearly endured enough. And this conduct is not just chilling to her, it's chilling to other people who would want to serve in her capacity. So, you know, we respect the ruling of the court, but take exception.
Temper
This
tantrum.
defendant is very well aware of what happens when he tweets about Ms. Freeman. We do not believe it is appropriate for him to make derogatory comments about anyone. He can publicly criticize me all he wants. I don't value his opinion. It doesn't matter. But what he may not do is publicly do things that intimidate witnesses. And so that needs to be clear. He should not be able to tag them so that they are communicated with or put them in open space so that Ruby Freeman now may have to move again and get another advisement
Yes,
from the
I'm sure.
FBI.
Yes.
And
It's
so
all
if you are,
Harrison's
I would
fault.
ask that before
I'm
Your
sure.
Honor leaves here today, that my team be allowed to sit down, that the defendant personally sign off on an
Well, that's
agreement
what you're about to do.
stating that an initial each clause so that it can be made more clear that he should not contact and intimidate witnesses in this case.
I don't have any concerns with what you've raised,
Yeah, that's
Mr.
what
Morrison,
the
Mr.
judge said.
Katroff.
That's what the judge just said, Fanny. Okay, he said that you're going to sit down and hash through the rest of the term. So they are going to modify it now. He stands up and he says, we're not signing anything. And then they say, well, let's go look at it. And you can see the courtroom ends. They spend a lot of time modifying the gag order or whatever the release conditions will be. And so there's Harrison Floyd. He got a big smile on his face right there. Look at that, Harrison. Looking sharp, man. I like the suit. I like the tie. Looking fresh. And it is a big, good day for Harrison Floyd. So we're going to wait, my friends, until we get the full order that comes out. We'll see what the modified order looks like. Get the PDF once it drops. But today, the big news, Fani Willis loses the revocation hearing. She wanted Floyd back in custody. He's not going back in custody. He's out. And it's because she overshot the shot. I think she really wanted this to be her big debut. Showed up, had a PowerPoint presentation and everything. I wonder how late she was up working on that. Didn't work because she doesn't know what she's doing. Her case is terrible. This is not a good showing for her or them. They are panicked because Harrison Floyd and others are communicating about the truth of the case. Jenna Ellis revealed a lot more about who she really is today by wanting Harrison Floyd back in custody. But even that, even with Jenna, okay, her proffer is mostly meaningless. She took a diversion deal that was in her interests, and now it seems like we know where she's alighting in this case, which is very curious. So that was revealed, but a good day for Harrison Floyd. Fani Willis loses the bond hearing. We, of course, will be continuing to cover this trial and all of the rest of the Trump trials. So my friends, thank you for subscribing. Thank you for liking this video. Thank you for going to robertgovea.com. You can get our daily show reports, the PDFs, everything that we cover here on this channel is there, robertgovea.com. And we have a daily newsletter that you can sign up for that will be delivered to your inbox. And we'll be looking forward to seeing you there and here on the next one. All right, my friends. Well, that is some good news today for Harrison Floyd. We've also got Elon suing Media Matters. We've got Trump suing for Truth Social lies, demanding $1.5 billion. But now it's time to hear from you and to see what you have to say about this. Of course, we got some very nice donos that came in over on the YouTubes and the Rumbles. Let's see who is in the house. We got Glenn Croy starting us off, bringing in 5 new membos. And thank you, Glenn, for bringing in the new membos in the house. Let's see who we've got starting the day off. Glenn Croy. Also, this one from this morning. Michael Allen Hughes. We missed you this morning. Sorry I ended the stream. Says Trump Donald's MAGA ticket 2024. And thank you for the facts. Thank you, Michael Allen Hughes. Sorry we missed you this morning. We got Glenn says, hey, this one from Honey Bear is coming in. Richard G, Saintly Beginnings. We got Rocky and Carol R all coming in courtesy of Glenn C in the house. Thank you, Glenn. We got Finn Contracting sent in a nice dono. Thank you, Finn. Finn Contracting sending in a nice message. We got another one from Finn. Says Joe Biden had a, quote, mostly peaceful protest happening on his birthday cake. Yeah, It was fiery, but mostly delicious, maybe, or something like that, right? To harken back to the summer of love. And thank you, Finn Contracting, for sending that one in. It was kind of symbolic. It was like symbolic of his presidency, up in flames. Rocky says DWAC on the NASDAQ stock is up 11% the past week. Just saying. That's a pretty good number there. Rocky Waters up 11. Maybe it's because it's reflective of the polls. Trump is doing well in the polls. Maybe people are reacting. Glenn also brought in new membos. What's up, Glenn? Bringing in Gloria B., Old Drill Sergeant, Queen Bee's Art Hive is in the house, Patrick R., and Irene A. All coming in thanks to Glenn Croy in the house. Glenn, another one from M.A. Allen, Cemetery Shop, Karen V., Rick S., and One Nation Underground. Glenn, you're the man, bringing in a bunch of membos in the house. We got Voice of the People says, it's about time. Let them feel what it's like to have the deck stacked against them, saying that we're excited about some lawsuits going the other direction. Feels good. Dolphin Fan is the man, bringing in 5 new membos. We got Po Boy, John G, Ricky G, Payday S, and CAM. All coming in courtesy of our friend Dolphin Fan is the man in the house. We got Glenn, another one from Glenn. Glenn, I think that's 20 from you, brother. Bringing in Villainy F, Renita P, D, Damsel Flea P, Patty, and Mary P, all coming in courtesy of Glenn. Glenn, thank you for bringing in all the membos. We got Pinochet's Helicopter Tours. Says, yes, Your Honor, I am indeed Augusto Pinochet on YouTube. And so it sounds like a nice channel, Augusto Pinochet on YouTube. Check out Pinochet's Helicopter Tours. Over on the locals, we got NY Renal MD says, this is not a legal order. The defendant has a right to proclaim innocence. NY says, she doesn't jail violent felons in Atlanta, but as other Democrats, she seeks to punish and jail political opponents. Her jurisdiction in this case is only because the county seat is in her area. One can argue that elections should be at the level of the AG. Well, and as we talked about yesterday, good doc, I think that she's doing her job prosecuting her political opponents. Like, this is her job. Kelly R says, Jenna Ellis is in violation then, because she's been mass posting all over X lately, some about the case. I know because I've lambasted her a few times. Wow. Well, Jenna, you know, she didn't need to send that letter in. She really didn't at all. Like, did you really think she felt harassed by Harrison Floyd? Really? Give me a break. That's pathetic. All right. So we got NY says, can anyone simply trade civil rights for bail? What if the prosecution states you must waive your Fourth Amendment rights and you can have bail? I think perhaps there is no right to bail, but you cannot extort these rights, in my opinion, on the whims of a prosecutor. NY says, if Jenna blocked him, she would not get a tag. End of story. Stop crying, from NY. A+ Computer Services says, Big Fani just got smacked down and and I think you're right about that. She did get a little judicial smackdown. Ray Ronk is in the house. Says, you know, a few months ago, I was really discouraged and you spent a good amount of time reminding me to be patient. I am now a regular member. Thank you. Ray, man, that makes me emotional, man. It really does. I felt a little something there in my chest. I'm not joking about that. So I'm really grateful that you are here and joining us, you know, and I know it's discouraging. I know there's a lot out there that is like really deflating, and I feel it too. But we're in it together, and we are going to win because we're on the right side of history, okay? We are defending things like natural God-given rights that are inherent and intertwined in the universe. And as long as we keep our energy up, keep our community strong, keep our heads in the game, we're going to be all right. We're going to win. So thank you, Ray. Thanks for becoming a member and for joining us in the journey. We're just warming up, buddy. We got John McGarvey bringing in 10 new membos. John, thank you. Bringing in Wild Horses, Toenail-less Cupcake, I think. You might want to double check that. NY Renal, we got Sodium Soldier, Audio Wizard, Pyramid 7, Prince V1. We got Christine coming in, Pablo Concepcion, along with Knowledge Tracker, all brought in courtesy of John McGarvey in the house. John, thank you for the very nice gift of the 10 membos. Marion Holtzman. What a nice dono, Marion. Thank you very much for sending this very generous one in. Says, I haven't caught you in a while, and thank you for the good news. It was fun. That was fun. The Fani story especially was fun. Today was actually a lot. I mean, it was good lawsuits. Fani is, got seated on her fanny by the judge. Like, what are you asking? What did you bring all these witnesses in? Honestly, that hearing could have been 30 minutes. The whole hearing could have been 30 minutes. In fact, the judge probably wanted it to be 30 minutes. But it was fun. Thank you, Marianne, for sending that one in. Let's say hello to our friends on the X before we wrap it up and go over to locals for a slightly curtailed after party. Who do we have on the X platform? 14 people are over here watching. Whoo! That's pretty amazing. Fred says, the investigator asked her attorneys and Ellis answered through them. I watched the hearing today. His attorney was very good. We got TJ King, Kaufefi's over there. Buffering's over there. O'Nelly says, don't forget to smash the like button. George is there. O'Nelly. Bryant Cartwright says both Gabriel Sharp and Willis herself said as public figures that criticism is par for the course. Freeman is a private citizen without social media, so Floyd was talking about rather than to her. Jacob says, what? Media Matters and like orgs somehow have old shelved accounts on hands for things like this? I mean, who could have seen that coming? Yeah, we've got Jonathan Maloney's talking about Arizona and some absurd decisions over here. And so shout out to our friends on the X platform. Thanks for following us over there. But now we are going over to watchingthewatchers.locals.com for our members only after party. And so come and check us out over there. We'd love to see you. Before we go, we want to thank our mods and our meme smiths who mod down the fort for us and keep things nice and orderly. And I think we forgot to do this yesterday. My apologies to our mods. Vienticus Prime, we got K Bean, we got Just Cause, Playin Hooky, Ronnie Cole, our friend Zulu, Beyond Geo, Zach Nichols, John Allen, Janek 909, Dog Digger, and Donut Mind Me, all modding down the fort for us, along with Geegum Geegum, Sleepy Dog Lee, and Nathan N810, all modding the fort down for us. But that, my friends, is it for us on the day. We are going to be back here tomorrow. It's going to be a beautiful Wednesday, Thanksgiving Eve. And I hope that even if you're prepping for your Thanksgiving, that you do join us right back here, because come and join us tomorrow, because we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.